out of argument.
Keep it so that
My lordship can go through it. I'll give it to it. Because why did my
I
lord?
can't go through.
My lord, why I say so? It is -6. Mathematically, I proved it -6.
Okay. Keep it in the file. Keep it in the file.
Deeply
Right,
obliged.
right.
Deeply obliged.
Right.
Yes, 136, my lord.
Adjournment.
Specifically fixed on the last occasion that it should be listed on 10th February 2023, my lord.
See, the boards are changing. I can't help you. Because today 95 matters. You just see.
4 below is proceeding, my lord. That is
What to do? Give the memos, see whatever. I can't assure anything.
Urgent bail matter मिला prior to vacation will
Bail
not
matters, bail matters, I am not going to entertain any memo because it has to come in serial.
Serially आसो नहीं
Serial, it will come definitely. Please wait, it will come. Have patience, it will come. Definitely come.
Lordship.
Definitely come.
file नहीं दिया
133 of 24. The matter amicable in between the parties, my lord, compromise matter.
Offense?
307 only.
Three only.
307.
307 is not only.
Sole accused.
The victim is lucky that he is saved.
My lord, injury also simple, my lord.
Lordship. 306, Lordship.
Settle, take it.
Matter is the year
Lordship.
21, my lord. I have given 4 times memos, but not yet been listed.
What-
21.
Bail-
CRLMC. CRLMC.
Madam, everything will come in serial.
ନାଇଁ
If
21
you-
ମସିହାର ଆଜ୍ଞା ମ୍ୟାଟରଟା
Huh?
21 ମସିହାର 22 ରେ ଆସିଛି 21 ରେ ଆସିନି 21 ର ମ୍ୟାଟର 22 ରେ ଆସିଛି
You didn't want that the matter should come.
no I have already filed 4 memos.
You file memo and in the
Not
registry
bail
you
matter.
manage not to be listed.
My-
That's the
I
problem.
let not bail matter but only crossing a paper.
21. In any case, in serial also it.
I filed 2 despite of judicial order, it is not coming.
I for what?
I for entry bail. There is a lady, no, connected, but
No, not on merit. Interim order for what?
interim
Interim
release of
bail
the-
for what?
interim release of the victim.
Why? When we're on health ground? What?
On a health issue. Both on the health issue.
We take the memo, just see if we can adjust.
Lordship.
Only in bail matters, only for interim bail, if you want to mention, mention. Regular bail matter, I'm not going to entertain any mention because it has to serial. Please don't jump the, you know.
Security ଅଧିକା ଆସିଲେ ହବ criminal mistakes କମେଇକି ସେଟା କରିଦିଆ
case is posted for charge.
I can't help. What to do? Revision for what? Revision against which order?
Against the attackment under Criminal Amendment Act. My
No, that's
my self-accord property has been attacked.
it's all right. It is contingent upon the conviction. No problem.
Case will be instructed.
Beg your pardon, madam. Your lordship was pleased to adjourn the matter on 23rd of August on the ground of compromise, your lordship. But inadvertently, in the order sheet, it has been mentioned at 23rd of September. But in the online status, it is showing as to 23rd of August, your lordship. It was posted to 23rd. Settled.
What kind of matter?
Bail matter, my lord. Victim is ready and willing to compromise the matter, my lord, and
Offense?
376, my lord. On the last date, my
No
lord. your
POCSO,
lordship-
no POCSO.
No POCSO, my lord. May I pray for tomorrow, my lord?
Not
The
tomorrow.
victim
Don't
is at-
tell tomorrow. I'll recommend it red mark करके करना. But we'll recommend it next week, but don't, not tomorrow.
Lordship.
Tomorrow, no, not possible. Everything will be upset, you know. I'm trying to put a system in place.
I'm deeply.
Everything is upset.
Next week, any date, my lord.
Please hold on. Yes. Next.
Great.
No mentioning on bail matters, please. Please don't mention bail matters.
Regular bill to ଅଧିକା ଆସିଥିଲେ ଭଲ
Huh?
ଅଧିକା ଆଇଲେ
ଅଧିକା
regular
ହେଲେ ଭଲ
bail
ହେଇଥାନ୍ତା,
matter.
Lordship.
No
File
mentioning
matter,
bail
file
matters at all. I will not entertain.
Urgent
Please
bail-
come.
Lordship.
Let it come.
Urgent bail matter.
Urgent bail ଗୁଡା
Urgent bail ଗୁଡା।
Don't jump the queue.
ଆମେ criminal mistakes
I tell you, there will be a lot of problems.
criminal mistakes
ପୁରୁଣା
କମିଟି
criminal
ଆସନ୍ତା।
mistakes ଆମେ ଉଠେଇବାକୁ
No,
ଚାହୁଁଛୁ,
no,
କିନ୍ତୁ
no.
regular bail ଦରକାର।
I have given instruction that no bail matter out of turn will be listed.
List
No bail.
ଆସୁ list ରେ
ଅଧିକା
ଆସିବ, କିନ୍ତୁ ଅଧିକା
ଆସିଥିଲେ
criminal mistakes ବରଂ କମିଯାଉ।
Whatever. 95
File
matters
matter
I
file
can't
ଦିଅ
handle.
ବୋଲି।
Please hold on.
କଣ
Next.
ଦେଇଦିଅ, consent ଦେଇଦିଅ, ଆମେ ଓକିଲ।
Item,
Bail you go. Yes.
My
Any,
lord,
any serious mentioning you tell me.
my lord,
Item-
item 80,
18.
my item 80,
80.
880, my lord, senior is there. I have called the IO for discussion bulky file. So let it, interim order is there.
He want to
Today,
disengage you now for today.
I have been engaged with Mr. Mahanti, Alok Mahanti. So
But
but
prosecutor
Yeah.
want to disengage today.
My interim order is there, let it continue.
Okay, interim order to continue, place it.
we are pressing for an interim order. That interim order is only file an application and that will be.
Oh, adjournment, that is the.
That intermediate order is also.
There are instructions to press the interim order.
The stay, it's a
Stay, I'll dispose it up. I'll completely dispose it up. They,
second.
We cross that bridge, Malats, when we come to that. Malats,
then are you opposing the adjournment?
I can't agree at the present, let it be called.
Okay.
Okay, all right.
My lord, pattern to
Interim
mention.
bail, my
Item-
lord.
Call the-
My lord, interim bail. Petitioner suffering a gallbladder stone, my lord. My lord, on the health issue, my lord.
Lordship, I kindly have a glance to the notice.
What do you want?
It connected three appeals. It has been noted that it is not yet replied. So my prayer before Lordship that three connected appeals, let the appeal section be directed to prepare the paper.
So forget that paper book system. I have abandoned that. That paper book system is not required. What
My
paper
lord, my lord,
book?
The
pattern to
health ground, my
mention.
lord. My lord, petitioner suffering.
Take up. Take the pen drive and take. I am ready to ask. What pen drive? Paper book primitive way of doing it. What paper book? Take the pen drive from here and argue.
Appeal has been filed by the appellant.
Appeal will be filed by appellant only. Appeal will not filed by you.
I don't understand why he is making a mention. We have to run to different courts. We need to make mention.
You are
My
only
You
you
have
sit
to
here.
wait till the end.
Yes, yes. you
Last
have to.
item.
Yes,
Your
you have
Lordship's
to.
last item today.
All right, but what to do? See, people are waiting for.
My lord, petitioner needs surgery problem, my lord. My
Any-
gallbladder
any-
stone.
In
My
the
lord.
list, my lords.
Hmm.
Item 86. The parties have settled a matrimonial matter. If your lordship will fix a time, I'll ask my client to
You
be
tell me.
online.
You tell me.
2 o'clock.
Today, bring them
Same page,
No, he'll be online, my lord.
online.
Based
No
on
problem. Matrimonial dispute.
Yes.
Let them come online. I'll pass. What?
My
Why unnecessary?
My lord, petitioner
Same page,
suffering, my lord.
item nine.
May I please your lordship?
And
My lord.
There is another matter.
yes,
Item 137 in the weekly list.
you be ready. The moment I'll exhaust my board, I'm ready to hear.
I'm there.
Be ready.
My lord, petitioner, my lord, petitioner suffering gallbladder surgery, my lord. It is urgency, my lord.
Whose surgery?
Gallbladder stone.
God
He's suffering,
is
suffering.
not
The
so
petitioner,
take-
my petitioner.
Take it after 1 week. You give. Yes.
My lord, pattern to mention.
My lord,
Item number
surgery
60.
needed, my lord.
The vigilance matter, my lord. Appellant has beared my lord. Wife has been substituted. It is not get personal benefit, my lord. Kindly taken off, my lord. Informant also not.
See, sir, when I was waiting for people to come and argue, you didn't come. Today, the board is so heavy and everybody is mentioning. How can I adjust you? Tell me.
Item
Pardon?
91
And
lots.
only midnight hearing is the only possible. 5 minutes for you. Thereafter, they will address and they have to write a judgment also. Only midnight hearing is possible. If you can come at midnight, convince the other side, come and
Pattern to mention, my lord. Item number 13.
let's proceed with the list now. Wait.
Outside court
Mention
settlement
tomorrow.
में अगर
Mention tomorrow.
Your lordship permits, my lord, may I submit one thing, my lords.
Yes.
91, my lords, I am told somebody has made mention, my lord. This is that matter where the petitioner counsel says that my D amount is less than 10%, my lords, and got the interim orders, my lords. My lord, this is an application, my lord.
91, Mr. Rai mentioned.
Mr. Raymond.
Mr. Rai mentioned, I have listed it Friday.
Right, my lord.
Item. My lord, pattern to mention. Item number 63. Kindly 2 weeks after.
63 adjourned.
Item-
Any adjournment you tell. me.
Item 67, my lord.
67, 43 adjourned.
37 and 40.
37 and
37, 43.
37 and 43. Sorry.
Item 67, my lordship.
Ah.
We need to file a reply affidavit, my lordship. My
Who-
learned
who is
brother is.
petitioner?
For the petitioner, my lord.
Write down.
My lord, item number.
Item 67.
67.
My,
The opposite party is second time.
my lord,
Interim orders to continue.
At the request of opposite party, adjourn to such day and interim order to
my
continue.
lord, item number 13. Pattern to next week.
Not next week. You ask for adjournment, we will decide which week.
Outside court settlement. Outside court settlement में चलेगी. Next.
Adjourn for October.
My lord, item 68.
58 permitted to withdraw. Yes.
Item 60,
60,
68,
68, yes.
68, permitted to withdraw to file better application.
Permitted to withdraw with the liberty to file a press one.
My lord, item 5 kindly adjourn after 2 weeks on behalf of DR Mahapatra.
Item 5,
Oh.
October. Yes.
Obliging.
Your lordship, some time may be granted to file the additional affidavit.
Who is appearing for the petitioner?
I am for the petitioner, your lordship. Opposite party.
Interim order is there.
Oh, your lordship.
Adjourn.
Item 62.
For filing additional affidavit.
Item 62, my lord.
Huh?
Item 62, my lord.
62.
My lord, this is the SC estimator. In the meantime, compromise between both the parties. Opposite party number 2 is not appearing in this case, my lord. So I pray, my lord, or 2 weeks after I will.
Adjourn. Yes.
Interim order.
Interim order is there.
My lord.
No, wait.
Oh,
Let it come. Let it come. Yes.
Item 1.
Please, your lordship.
Please, your lordship.
Yes, sir.
I beg your lordship's pardon for giving pro de memo, lordship. Your lordship on the similar matter, it was passed this order. So, if your lordship permit me, the main talks of the matter, the petitioner in the way back in the 2005, my lord, availed a TL loan, colloquially it is Suvidha loan, and he has already liquidated the loan amount. And the branch manager has also made a statement before the investigating officer that the
You
petitioner.
are challenging cognizance order.
Yes, cognizance order. And in the similar matter, another loaning, your lordship has passed this order.
So,
Your lordship permission.
you are one of the sleepy. Have you checked it? Have you checked it?
Yes.
I have
The same city case. City case number 4277.
Show me the bank manager statement.
Yes. May I invite lordship's kind attention to page 26 below.
Yes.
Page 26 below.
Yes, 26.
Last but one paragraph.
Yes.
Out of, my lord, may I read, my lord? Out of one loan is
26,
12 loan is namely Prashant Kumar Pradhan to Prahalad Mahanti.
Where are you reading? 26, second para.
Yes.
I am working as a branch manager.
Last but one. Fourth para.
Sir.
My lord, out of 51 loan is 12 loan is namely Prashant Kumar Pradhan, so and so. Then Ramesh Chandra Shubhudi.
Yes, so and so.
And Kasinath.
Serial number 8.
Serial number 8, the present petitioner. And the serial number 3, your lordship has already passed the order, which is before lordship's vote.
Yes, what do you say? Huh? Right on. It is hurt so. How much loan you have taken?
5 lakhs already deposited.
5 lakhs.
Huh?
Along with the allegation against the petitioner is that he, along with 53 others, had taken loan from the State Bank of India to the tune of rupees 1 crore 1,17,05,000 by manipulating the loan documents. Insofar as the present petitioner is concerned, he has taken a loan of rupees 5 lakhs.
Yes.
From the State Bank. On the basis of the complaint from the regional manager, State Bank of India, EOW CH case number 29. 29?
Hello?
Case number 29.
Yes.
Of 2023 under sections 419, 420, 468, 467, 471, 120B IPC has been registered. Then counsel for the petitioner has pointed out from the bank statement. Where is the bank statement? Where is the bank statement?
Pardon?
Where is the bank statement?
On page 26. Lord.
That is statement where you have to show me the bank statement. Show me the bank statement where your bank.
Lord, page 17 below. 17.
17.
17.
17, yes.
Lord, got it?
Yes. This is certified that Mahapatra No outstanding, yes. Learned counsel for the petitioner has taken me to the taken me to a certificate placed as annexure 2 series, which indicates that the State Bank of India has given a certificate that you are Kasinath Mahapatra.
Yes, Kasinath.
Given a certificate that his demand loan account number 107-507-61035 has already been closed, and all the outstanding dues towards the Suvidha loan he has availed has already been paid. This aspect of the matter has also been confirmed by the manager in his complaint. His complaint, this is 26, na?
Yes.
26. This is the complaint?
Yes. Annex 3, my lord.
26.
Annex 3, my lord.
26. In his statement, in bank manager in his statement, the statement reads as under, out of 51, it will page 26, out of 51 loanees, that's pura kar do, the paragraph.
This case can tag with that
Yes,
element.
yes,
Mr. Suren Senapati.
That case urgent, my lord. This case can tag with that
Yes,
case, my lord. And both will come together.
Together.
No, the Surendra Nath Senapati's statement under section 161 CRPC has been extensively read out, which indicates that the petitioner and 11 other loanees have repaid their amount. Similar was the situation in case of Ramesh Chandra Shugudi, who had filed a criminal AMC number 3576 of 2022. 2022. Mr. Das seeks parity with the said accused Ramesh Chandra. Issue notice to the opposite party number 2 to 4. 2 to 4, na?
Yes.
Opposite parties.
Opposite parties.
Returnable on so leave the matter on. When this matter is coming up, just check it up. When this matter is coming up, in the same day like this, okay. In the international, the proceeding in EOW PS case number 29 of
Corresponding city case.
13, corresponding to city case number 4277.
Yes. Yes.
4277 of 2020, pending in the court of SDGM Bhubaneswar, shall remain state with the next date of hearing.
Of diplomatized, my lord.
Yes. Tag with please the matter along with that. Yes.
Urgent chapter.
Two.
Yes, Lordship.
Yes.
For the last Friday, your Lordship directed to appear with the personal appearance of the petitioner and victim. And already now the present before this honorable court.
Yes.
And already the victim has already filed the affidavit that is flag B, your Lordship.
Call them. Who is the victim? Who is the victim? Victim is
flag B, kindly glance here for a moment. Your Lordship.
charge sheet under section 326.
That is annexed 2.
And married.
Yes, your Lordship. I have annexed marriage certificate and flag B, your Lordship.
So, flag
B, flag 5, your Lordship, marriage certificate.
Yes.
My lord. Though this case coming under the Procedural case. But in fact, the Honorable Appeals Court in recent decision, my lord. They are, my lord, the after conviction, my lord.
Because there in that case which you are citing, there what had happened is conviction is satisfied by exercising 482. Therefore, they give that. But the reality is they are married now.
This is coming under the Procedural.
What was the age of this girl?
19 years old.
At the time of incident.
At the time of incident, before 17 plus, your Lordship.
Now she is 19.
19, your Lordship.
How she is married?
Section 5 from the Social Marriage Act, your Lordship, that is flag 5, your Lordship.
You say she is 19 now. Marriage certificate, huh? Special marriage.
Fact 5, your lordship.
Yeah, ask her. Where is the accused?
Accused here. Come.
Just ask whether she is happy or not. The opposite party number 2, FIR number so and so came to the registered against the petitioner. Litigation against the petitioner and so and so. After investigation, charge sheet has been filed. The petitioner, the opposite party number 2, was examined by the petitioner number 2 in her statement under section 164 CRPC has stated that the petitioner was in a relationship with
One problem is one problem is mother the information.
Mother is not there.
Mother, they cited as opposite but two mother, he has not.
Mother, who is appearing for mother?
But so far, mother did not agree with the marriage proposal of the party.
Then again there will be a problem. Na? She will go and challenge this order. She is the informant.
But facts, but facts mean that the marriage
I will record everything. I will record their presence. Let them be free and bring the mother and pass. So that they need not come to the court again. I'll make them free. Okay. For the procedure, otherwise again these people will be in trouble.
But facts, but
don't argue.
She is not made the opposite party. But in fact,
I have married as opposite party on 2 informational.
Then you serve. Bring see that she was in love relationship with the petitioner, and the petitioner has promised to marry. And she in the month of December had gone with the petitioner to Puri. And stayed there for about 3 days. Again in the January 25th day, again she had gone to Puri with the petitioner and stayed overnight. And after withdrawing the money from the bank, they came to Bhubaneswar. At that point of time, the auntie, at that point, the maternal aunt of the petitioner saw and took her to the hospital, took her to the police station where she lost the FIR. When the matter, the charge sheet was charge sheet has already been filed. The petitioner and opposite party number 2 are present in the court, identified by their counsel. They have also filed self-attested copies of their Aadhaar card, which is to establish their identity, which are taken under court. The petitioner and where is the affidavit? Who has filed the affidavit? Where is that affidavit?
Victim, Lordship.
The victim,
yes, sir.
opposite party has filed an affidavit dated
Detail Lordship.
Dated 23/8/2024 inter alia stating that she has already married with the petitioner, and she has also filed the parties have also filed marriage certificate issued by the marriage officer.
Khurda at Bhubaneswar, Lordship.
Marriage officer.
Khurda at Bhubaneswar.
Bhubaneswar. Dated 16/12/2023, which reveals that the petitioner has already married with the opposite party victim. The petitioner, in the present case, the mother of the victim Mother, you have not implicated her, na? Obviously. Mother of the victim is the informant. Despite notice, she has not appeared before court. Since the informant in the present case is not has not yet appeared in the court, therefore, by way of last opportunity, the matter
Also, notice has not been issued, my lord.
notice has not been.
No.
Not appeared. It would be
Notice, my lord,
appropriate. It would be appropriate to issue notice to opposite party number 2. Accordingly, notice is issued to opposite party number 2, and the notice shall also be served through the eye of the present case. Present case. Please the matter on certain sir.
Free copy, daughter.
3 copies.
May I pray one thing, Your
Next.
Lordship? Let be notice issued to OP2, but so far my IA is concerned, further proceeding of this.
Further proceeding
Before the learning.
So is take.
Yes, Your Lordship. Deeply.
Next. Yes.
POCSO. POCSO or
Urgent. Yes. Next.
Item 4.
No passport today. At the request. Yes.
My senior will have good.
Item 6.
Urgent. Six.
Lordships, may I mention item 3? I'm so sorry, my internet went off, so I could not join in time. Lordships, item 3. So I had to join from my phone because the yes.
Yes. Tell me, ma'am.
Lordships, this is a case where I'm seeking a quashing of FIR. And this is an FIR which has been registered under section 13(1)(d) and section 2 of the PC Act, in addition to sections 120B and 420 of the IPC. And Lordships, interestingly, this is a case where originally when the FIR was registered, my name was figuring nowhere in the FIR. And this was in 2005.
Come to the charge sheet now.
After 7 years, they get the charge sheet filed. And there my name suddenly miraculously figures in the charge sheet. And there is absolutely no role attributed to me. It is a case where, Lordships, there is more to it than meets the eye, which I'm going to present before this honorable court.
Let's come to the
Lordships,
charge
on the
sheet. Let's come to the charge sheet.
Yes, Lordships. Please,
Please
Lordships.
alleged against you, let us.
The charge sheet. Yes, Lordships. So in fact, what is alleged against me is, I'll just give the relevant page.
Yes.
Yes, there's just one para on me. Okay, we can pull on the phone so can just over to. Yeah, just switch the tone. Just switch the tone. I'm so sorry, Lordships. Extremely, I'm so sorry, Lordships.
Leak it up to 2 weeks.
Item 6.
Yes.
On behalf of Akshay Kumar Sahu, yesterday he has filed additional affidavit. That is not come in the court.
Then
Next
next
week,
submits that yesterday he has filed the additional affidavit.
Yesterday.
Copy of the same has already been supplied to the state council. Lease the matter. Yes.
Item 7.
Allegation has been made against the principal by the students for late issuance of certificate. And in that matter, the compromise has already been effected. And they have also filed their affidavits to the.
No, why have I adjourned it to make them appear?
Per the appearance.
Yes, make them appear only.
All will appear.
It can't be quashed in absentia.
Appear through VC.
Yes, I told that.
They have not appeared.
Through VC. VC paper will be.
You see the accused and the complainant has to appear.
Next week,
Adjourn
Item
it.
8.
See, the let us for the petition submit that the matter has already been settled. The matter has been adjourned time to time for appearance of the accused and the informant. Even today, adjournment is sought on that count. leaves the matter of sunset. It made clear that on the next that of hearing, if the listener and the informant shall not appear, the matter will be heard on its merit without taking into consideration the aspect of settlement. If
May I-
don't appear, then settlement aspect is gone. I'll hear in the merit and it will.
May I please, my lords?
Yes.
307 and the joint affidavit.
Item, sir.
8, my lords. 307 and the joint affidavit is been filed by both the parties.
Now, what are the allegation?
Allegation is 307, my lords. Go. All that appeared filed.
What happened in this case, my lord? There are concert injury, my lord.
My lords, that my lord is directed to give a decision. Already given.
They have decision files. They are the knife value injury, my lord. Here, my lord, the concert.
No, that is serious injury. Serious
injury.
Concert injury.
That my lord.
They are, my lord, they have
Yeah,
cited.
I have not written any period or
They are cited decision, my lord. They are the knife injury, my lord.
Where have I said that in the order? Nothing is there.
But the file, must be in the file.
Proceeding. No, but proceeding, I have not written any proceeding that you have appeared, anything of that sort. Simply urgent.
But they have appeared.
They have appeared.
Maybe you let them appear, I will consider.
Huh?
Let them appear. They have not appeared. Even if appeared, it doesn't reflect in the.
Reflected, madam, that's not reflected, but they have appeared the file there, joint affidavit, my lord, that on
But
that
it is a
decision of-
gunshot injury.
But that's
Part of the body.
My lord, the
So I find the injury.
left side.
Which part of the body?
Left side.
Huh?
belly.
Then he was admitted to hospital for how many?
My lord.
Huh?
Compromise, madam.
Compromise doesn't mean that in murder also you can compromise.
Grievous also injury, grievous.
Injury, see, show me that gunshot injury,
And
307.
No, no,
I
that
can
my
pass.
lord.
Last week, they are filing, that is.
Either
It is 307 by knife, but it is also serious. 3 injury are serious, one is simple, my lord.
gun, you have, gun is recovered also.
my lord.
Gun is recovered.
And that's
The first paragraph, madam. On the basis of the compromisation also, for accused in the FIR and respondent number 2.
In this case, it is something, it's not gunshot.
Not serious, my lord.
Huh?
In this my lord cannot pass, my lord.
Huh?
Here, my lord, 307 can.
Can't be. That's the whole difficulty. Gunshot. If
Well,
you can
because
convert it to
intervention-
326 or 323 kind of thing situation, I do it.
They have knife use.
There is this I know, just Sigri's judgment. I know that.
In this judgment, my lord, Supreme Court held that, though,
And you see the other judgment we say.
Well,
intervention of the Sarpanch and the gentleman
Gunshot,
of
na?
the locality, my lord.
Gunshot. In any case, why should I waste time? Let them come. We'll see. Yes. Urgent simply. Next.
Item 9.
the adjourn to next week, my lord.
Be ready for some alternate prayer. I think I should expedite the trial and finish it up. If he is not supporting, he'll go and he will be examined as a witness. He may, be hostile and he will be acquitted. No question of quashing. It's better that you should. I will expedite.
Let
the
it,
trial.
my lord, I will take instruction, let it come on.
You come so that I'll expedite the
Yes,
trial.
my
Target it. I record that you have settled, but I'll not quash. And but in the peculiar facts, I'll direct the trial court to expedite the trial. So
Okay,
that the victim will be examined first, and when you are out, that's the best way of doing it.
Yes, we'll take
Balancing act.
What is the stage of trial? Well, I will take
You just check it up.
my lord.
You check.
Next week,
If the victim has already been examined, then if you have supported the prosecution, then you have a further difficulty. Then in that case you have to move an application on 311 for recalling of that witness. Just verify.
I kindly take it to next week.
Yes, yes. You find out the ways. I'll
Madam.
not quash, but in what way it can be done, you just think over.
My
Yes.
Item 9.
Yes, sir.
In
And
this-
take the judgment, sir.
yes, yes.
He is giving some judgment. You have to deal that with that judgment also. Yes. Next.
In this case, I am challenging the order dated 3/7/23, annexure 3, my lord.
Yes.
That is regarding without taking evidence from the complainant, close the evidence from the complainant side, my. One transfer application is pending before the law decisions cut up. It's annexed 2, my lord. LCL call for. Annexed 2 is the.
What is this order 37?
At page 19.
You are agreed by this order.
Agreed.
What is this order is about?
Without taking evidence from me, close the evidence. The complainant deliberately is avoiding to receive from someone.
But what to do? The court is after you. Every time trying to serve,
Actually,
you don't come.
I am residing at Bhubaneswar, for which I have filed a transfer application before the law and decisions. Correct. That is pending.
Pending doesn't mean that you will not. And he closed the evidence. What to do? You don't go. You file a transfer petition. You don't go to the court. The trial court says that despite the fact the service is complete.
Service is complete.
You are present in the court.
The witnesses are filed before the.
Now, to what happened to transfer petition?
My lord?
What happened to transfer petition?
That is pending.
Pending. Then till that transfer is pending, it is not decided, you will not prosecute this case. Have you got the stay in the transfer petition? Have you got a stay order in the transfer petition? Then
only LCL.
This will proceed. When the next date of hearing?
My lord?
Put up on 3rd August. Now, when the fix?
I have no instruction.
You should come with a full instruction. What is this? On the how many witnesses you want to examine?
No witness to examine.
You want to examine yourself only. Only you want to examine.
Madam.
Yes, Mr. Goda. See, what had happened is the evidence of the complainant was closed. Because the complainant has not cooperated. Why he has not cooperated is he has filed a transfer petition. A transfer petition is that he will not go. That's the case. But what I'll propose is I'll give one opportunity to him to lead his evidence on the next date of it.
Since I have to complain that way.
One opportunity. I don't. Petitioner is agreed by the order dated. Petitioner is agreed by the order dated 3/7/2023, whereby the court below has closed the right to record the evidence of the complainant in view of the fact that sufficient opportunity was afforded to the petitioner, being the complainant. However, he did not avail the same. And consequently, the petitioner submits that the petitioner, in fact, had moved a transfer petition before this court, being transfer petition number 2. 2 of 4.
TRP 2 of 2023.
2023. 23. Since the transfer petition was pending, he was not prosecuting the complaint before the court below. It is also it is apparent on record that in the transfer petition there was no stay of further proceeding insofar as ICC case number 82 of 2012 was concerned. Therefore, the petitioner ought to have prosecuted the complaint. Be that as it may, since the right of the petitioner to lead the complainant evidence has been closed by the court below, I am of the considered view that the petitioner is entitled to an opportunity to lead his evidence. Accordingly, the JMFC Narsinghpur is directed to afford a single opportunity to petitioner to record his evidence, being the complainant in the ICC case number 82 of 2012. It is made clear that under no circumstances petitioner shall be afforded, no circumstances petitioner shall be allowed to take adjournment, and petitioner must record his statement on the date fixed by the court ruler. With this observation, the petition is disposed of. Yes. Okay. Next.
Item 10.
Yes, sir.
Petition challenging order dated 9/6/2021 by the Learned JMFC Pipili in GR case number
Yes.
290 of.
Forget the numbers. What is this case? What is this order?
My lord, page 42, my lord.
42? Yes.
Cognizance order.
Cognizance
My
taken.
lord.
Yes.
Petitioner and the informant both are the same family. Due to civil dispute relating the land property, the informant has posted a case petitioners. Petitioners for my lord Gitanjali.
A FIR was registered against you.
My lord.
And final form was filed.
Well,
thereafter, the complainant filed a protest petition.
No.
Charge sheet.
Charge sheet.
In the
Charge sheet and prime facie case old made out.
What is this complaint then? Annexure 2?
ମାନେ ଦି ଯା ଭିତରେ ସାନ ଯା ଦେଇଛି ବଡ ଯା ବିରୋଧରେ କେସ୍ ଆଣ୍ଡ କାଉଣ୍ଟର କେସ୍ ହେଇଛି ଆଜ୍ଞା ଆ ଭିତରେ ମ୍ୟାଟର ବି ସେଟଲ ହେଇଯାଇଛି ମ୍ୟାଟର ଇଜ ପେଣ୍ଡିଂ ମାଇ ଲର୍ଡ ବିଫୋର ଦି ଜେଏମଏଫସି notice kindly
issue notice to this party number 2. Yes.
I have filed
IA, let it be. You settle, why do you worry? Yes. I intend to dismiss it with giving you liberty to urge whatever you want. Only he says that to give notice because there is a settlement chance, therefore I am doing it. What is the question of saying you have settled the issue? Yes.
Item 11.
Lordship, on last occasion, directed and both the parties are present.
Last occasion only at
settlement. Settlement. Your Lordship, they are coming. Only.
Okay. Yes. Next. Yes.
Item 12 may kindly taken up next week. Mr. Maharada is held up in court number court number 3.
Yes.
13.
For a short argument, my lord.
13.
Yeah.
You are speaking in adjournment? Oh.
Cognizance is 20. Cognizance of 20.
What will you do? Cognizance is
only 506. So outside.
That's right. What is the stage of the trial?
Trial of just for first appearance, the case is Arjun. So there is only 506 is the normal the offense. So there is a talk of compromise. That's 8.11.
Okay, ठीक है. Compromise हो जाएगा ठीक है.
Okay.
14.
See, if there is a compromise, what I'm proposing is 506 only. Shall I send it to mediation?
That will be a better man.
Better. Why unnecessary?
My lord,
Trial court will be the burden.
My lord, 325 is there. Injury is grievous in nature. He has right hand fracture.
Compromise compoundable 325.
Compoundable.
Only
mediation जान तो कौन हो? 13 लिखो. The land council for the petitioner submits that the courts are so burdened. Let it be over. Unnecessary. The land council for the petitioner submits that the parties have have you implemented opposite party?
I am for the best out of your lordship.
These are minimum things you don't do. What you do? You write down. Land council for the petitioner seeks permission to implead the informant and injured as opposite party number 2. Permission granted. So issue notice to the newly implemented opposite party number 2. So accept notice for state. And then council for the petitioner submits that the parties have already in the process of settling the dispute. In view of the same, I feel it appropriate to refer the matter to High Court mediation center. The coordinator of the mediation center, High Court Mediation Center, is that directed to fix a date of for exploration of settlement and intimate the same to all concerned. Awaiting the mediation report, release the matter. Okay.
Item 14.
14, my lord, discharge petition has been rejected, my lord. Page 12, my lord. Last occasion, my lord, directed to file FIR copy 16151 charge sheet. We have already filed, my lord.
Yes.
In the meantime, my lord, warrant has been issued, my lord. Well, kindly see the warrant order.
I'll quash the warrant order, go and face. I'll quash it right now. Here, right here. I'll quash the warrant order, go and
Surrender.
Huh? Maybe lady, but there is a case against you. What to do? You are not protected also.
No.
What are the offenses?
498A 109. His main claim is that ground is that she is not the second wife of the.
Those things
that will be decided at the time of trial.
I can't decide it now. Evidence is required for that. You are protected already.
Yes. No.
Huh?
No protection.
498, you will get the bail. What is the big deal about? Same day, I will pass an order. You go and appear, and same day, your bail application will be rejected.
Let them notice will go, my lord. Till then, my finally mistakes for stay for the proceeding, my lord.
No, I will not stay. There is no question of stay. I will pass this NVW order and ask you to go and appear, and the same day your bail application will be decided. Decided. That is a better idea.
Yes.
The petitioner has said the order dated 1/23/2024 passed by SDGM Bhadrak N.G.R. case number 1705 of 2021 corresponding to PS Pirhat PS case number 98 of 2021, whereby his discharge application, his application for seeking discharge has been turned down. And counsel for the petitioner submits that meanwhile, while order dated 28/5/2024, the SDGM Bhadrak NBW against him. He hands up for the certified copy of the same order. The counsel for the petitioner further submits that he has been arraigned as an accused in the present case on the allegation that he is this second wife of the principal accused. Principal accused. Principal as alleged by the opposite party number 2. As alleged by the opposite party number 2. The facts to be elucidated in the trial. I am not inclined to entertain this petition. However, the petitioner being a lady, it would be expedient. It would be appropriate that she would appear before the court on or before 15th September. Appear on or before 15th September 2020. And the NBW order issued against him by the 5/2024 shall remain kept in events till that day. If the petitioner appears before the court and moves appropriate application for grant of bail, the same shall be considered on the same day, on its own merit. Till then, no course of action shall be taken against the petitioner. Yes. This was this observation. Right.
15.
May I please, Your Lordship?
Yes.
Question of affair on the ground of compromise, Your Lordship. The matter was referred to the mediation report and mediation report, Your Lordship. There, in total, 10 lakhs was final amount,
What are the
and 8 lakhs was given, and today the informant received 2 lakhs in cash, Your Lordship. They both are present before this honorable court, and
this is mediation report.
No, my lord. This is the money received today, lordship. She has accepted
Totally 10
10
lakhs.
lakhs. She has
8 lakhs you had already paid, 2 lakhs today you paid.
Yes, sir.
Who is the informant?
The mediation deposit.
Where is it? Ullas Bari?
Yes, sir.
And 16.
There are three petitioners before my lord, and they are aggrieved by the order at Annexure 1,
Yes.
order of taking cognizance under section 498A, 306, 304B, 406, and 34 IPC,
Yes.
read with 4 of the DP Act,
Yes.
my lords.
Yes.
My lords, thereafter notice was served to the informant opposite party number 2. My lords, seniors appeared for the opposite party, my lords.
Yes.
My lords may turn to Annexure 4. An affidavit has been filed.
But 304B.
304B is there, 306 is there.
My lords, but the affidavit has been filed.
That's all right. Everything is accepted. But you show me any judgment, anything you have with you. But 304B also can be done.
This is not a case under 304. Because the charge sheet itself shows that it is due to ingestion of
Poisonous.
Yes.
Herbicides, my lords.
What the medical report says?
My
That
lords,
is the medical.
my lords will turn to page 29, my lords.
Page 29.
29. 29. Yes.
The ongoing paragraph,
29. Yes.
8 paragraphs from the bottom, my lords.
Yes.
The MO in his inquiry report opined that the death of deceased appears to
Where
be
are you reading, ma'am?
Page
28.
the
The
first
on
paragraph,
Last few lines.
6th line from the bottom.
Okay.
The MO in his inquiry report opined that the death of deceased appears to be due to ingestion of paraquat poison, herbicidal poison, and its complication thereof. The death of deceased, it appears to be suicidal in nature,
Suicidal nature.
my lords.
Well, that is also the visceral report. But my lord, 306 is there and 304B is there. Is
306,
it
but,
compoundable?
huh?
Is it compoundable?
304B is a presumption. Because that is
Yes,
a
ma'am.
presumption. That's not a problem. It is a case of
306 is there.
306. Do you have any judgment to
My lord,
oppose
the
it?
Dex 7 case is clear.
Huh?
Dex 7 case clearly stated that the heinous crime cannot be compounded and in lieu of money, my lord.
Where is the question of money here? There is no question of anybody.
Who is the informant?
My informant is the
Who has
father.
paid money to?
See, then that Gyan Singh also says that if there is a blink chance of conviction,
Exactly.
why should unnecessary?
My lord, let the trial, but the trial will, your lordship may directed for expeditious trial. There you will try their luck, my lord.
Oh, you
I do
Why
not
there, my
know
lord, this type of offences will be compounded.
I
by the
understand that.
compromise.
Therefore, so much of time. Otherwise, 2 minutes I'll take. But you have any supporting judgment? See,
Well,
it's a case of suicide. The girl has suicided, committed suicide. There is no doubt about it. Second thing is torture and all. And now the who will be the vital witness? The informant. The informant comes and compromise. If you even if you put to them to trial, the same thing is going to happen. What are you going to achieve? Pardoning the system.
No,
That
no,
is the reason 482 is invented.
that is correct, my lord. Either this is a offense which is a civil in nature,
Don't say general thing. If you can show me any judgment.
I will bring my lord. Only Dex 7 judgment there. Other
Yes. Parties are present.
Parties are there.
I'll record their presence and exempt, and on academically we'll decide on this thing. So at least you support those things so that in these kind of cases, wherever it comes, we can employ that and do it. Okay, you research that subject. At least these parties, I will make them, right on. At the instance of opposite party number 2, FIR number so and so came to be registered against the petitioner. Allegation against the petitioner is such and such. Okay. The charge sheet has already been filed on 28/12/2023. From the reading of the charge sheet, it reveals that the deceased has committed suicide by injecting what is that?
Ingestion.
Ingestion.
Injecting what?
Injecting.
Ingestion of
paraquat poison.
Ingestion of paraquat poison. The informant in the present case is the mother of father of the deceased. See, he has now settled the dispute with the petitioners and has filed an affidavit before this court on 1st May 2024. inter alia stating that he doesn't want to prosecute the petitioner. The case was filed on misunderstanding.
So he was unaware that it was a suicidal. That's what he has specified.
He has also stated that he was unaware of the fact that his daughter has committed suicide. The prisoners and the opposite party number 2 are present in the court, being identified by the respective counsel. They have also filed the self-attested copies of their Aadhaar card to establish their identity, which are taken on record. The counsel for the state submits that the case being the allegation being serious in nature, exercise of 482 jurisdiction in such a heinous crime is barred. Exercise of jurisdiction of 482 should be sparingly used in such cases. He wants to support his contention by way of judgments of Supreme Court and different high courts, and therefore he seeks an adjournment. Leaves the matter for further hearing on the next date of hearing, the presence of the petitioner and the opposite party number 2 is dispensed with. Leaves the matter for the purpose of.
I make a small prayer.
Yes.
Since it is being adjourned, as an interim.
Yes, I'll state. I'll have to state. In view of the peculiarity of the present case, the proceeding before so and so is state. Only that academic issue I'll decide.
Yes,
But come with full written submission, and you will also do. Don't travel. You have to do it. You have to do it. Get some judgment so that I will write a judgment so that in other cases also we can utilize that. Okay. Further proceeding in so and so is state. I'll just come with
Yes.
Here, my lord,
You are the
owner.
He's the accused
exact.
homeowner.
Okay.
And there is no bar, my lord, in NDPS Act to release the vehicle in favor of the owner.
Confiscation proceeding?
Confiscation, my lord, in that is arose at the, my lord, completion of the
Completion
trial.
of the trial.
In view of the section 60 and subclause 3 of
52
the.
also.
And therefore, in a similar case, my lord consider and also Basudev Singh versus State of Odisha 2022 87 OCR. Page
Yes.
161.
And one read petition was decided by our Honorable High Court. That there is some direction was issued for the interim release of the vehicle. And his
No, because see, section 60 says that after confiscation proceeding, if at all 357, it is only interim only.
Only interim
Subject
matter.
to outcome of
trial.
Yes, ma'am. And in all the judgments, my lord, Supreme Court and our own High Court judgment that vehicle should be released on interim basis. And though it was there is a revision, he has not preferred revision, directly come to 482.
This is revision. Right on. Right on. Petitioner is agreed by the order dated 14/3/2024.
Yes.
Passed by SDGM Pulwani in Miss case number 16 of 2024, seeking release of 24, whereby his prayer for release of Bolero pickup bearing number OD -33 AD -1361 61 has been turned down. The petitioner has moved an application under section 357 CRPC. Petitioner is an accused in FIR number so and so. It is alleged that in the petitioner, being the owner of the vehicle, was carrying contraband in the subject vehicle. Therefore, the vehicle has been seized. The petitioner moved an application under section 357 CRPC for the release of the said vehicle. By the impugn order dated 14/3/2024, the learned court below has rejected the application inter alia, stating as under page 38 in the sum and substance of the above discussion. 38 in the sum and substance of the above discussion, in that paragraph, and continue.
Yes, ma'am. Page 39.
39. Pura continue. 39. The trial court trial court apparently rejected the application for the petitioner under section 457 CRPC, relying upon the provisions, relying upon sections 52 capital A for NDPS Act. And counsel for the petitioner has relied upon the judgment of this court in criminal MC number 2924 of 2022. Lipu alias Prabhat Kumar Swami versus State of Orissa, dated 23/11/2022. He has emphasized which paragraph?
Paragraph, last paragraph.
Paragraph 10.
Therein also the petitioner was an accused and owner himself.
Paragraph 10 of the judgment, which reads as in the said case as well, the petitioner was the owner of the vehicle and also accused in the case. Now the coordinate bench of this court, by relying upon the judgment of Vasudev, relying upon the judgment of Vasudev Singh versus State of Orissa, reported in 2022, 87 OCR 61 have stated that even if section 63 so 660 bracket 3 of NDPS was provided for confiscation, the same would be done at the conclusion of the trial. Therefore, the application under section 457 CRPC for release of the vehicle in the interregnum period is not barred under the is not barred. Accordingly, release of the vehicle was directed in that case. Having taken into consideration the facts of the present case and the judgment relied upon, and for the consent to do the petitioner is entitled for the relief sought by him by moving application sought by him. Accordingly, the impugn order is set aside. The court below is directed to issue appropriate direction for release of the vehicle in subject. With such condition deemed fit and proper, and subject to further condition that subject to the confiscation proceeding, if any, or to be initiated against the petitioner. With this observation, the petitioner.
That to follow the direction made by this honorable court in WPC number. That is, my lord, it was reflected in page 38, my lord.
13.
38.
Conditions are there.
38, my lord.
Photograph taken.
38 of who?
That petition, my lord. 38. That in view of that petition civil number 32580 of 2021.
Photograph taken.
The learned court below is also directed to impose
follow the direction.
Necessary condition.
Follow the direction issued in.
Follow the direction contemplated in the order of this court in writ petition number civil number 32580 of 2021 in the matter of state of Orissa versus Registrar General Orissa High Court, Qatar, while passing a direction for release of the vehicle. Yes.
Item 18 I may be permitted through VC, my lords.
Yes, sir.
My lords, order taking cognizance is under challenge. That order is at running page 11, my lords.
Yes.
Cognizance has been taken under section 498A, 307, 323, 494, 30 per IPC. But the present pair is only confined to offence 307 IPC, my lords. On the ground, my lords, page 13 and 14 of the brief, your lordship kindly see. Page 14, that is the injury report, which shows that the injury is simple in nature, my lord.
Injury?
Injury is simple, my lord.
Sorry, I didn't follow. Injury? What you are saying? Injury?
Injury is simple. Injury is simple in nature, my lord. Page 14, your lordship.
Simple in nature.
Yes, simple in nature, my lord. I have
Cognizance is taken.
498, 307.
All these things, all these things you have to argue at the stage of charge. Because it's simple in nature, 307 is not made out, and all these things you have to argue at the stage of charge.
My lord, sir, so the Honorable High Court, exercising 482 Millers has ample power, Millers, to interfere, Millers.
Court has to see other documents also. You have filed only one injury report, you are arguing the matter. The entire evidence on record has to be seen. Even if it is simple injury, if the intention is there,
manner of
307 can also be, attracted. You never know.
So,
then what are the other evidence? Who knows? I am giving you liberty, go and argue. Learned Counsel for the petitioner has challenged the order dated 26/9/2019, passed by the court of JMFC. What is the charge has been framed? It is 2019.
No, 2009. That is true, Millard. I have taken instruction. The case is posted for charge, Millard. Yes.
Achha.
I have taken instruction.
JMFC in ST case number 63 of 2023, whereby the the court below has taken cognizance of offenses under section 498 capital A, 307, 323, 494 and 34 IPC against the petitioner. Land counsel for the petitioner relying upon the injury report submits that since the injuries are simple in nature, the cognizance of offense under section 307 taken by the court below is not sustainable. He has also taken various grounds attacking the cognizance order. Primarily, the land counsel for the petitioner is seeking primarily the land counsel for the petitioner is making a grievance regarding the nature of offense, cognizance of which has been taken. I am not inclined to entertain this petition at this stage. However, liberty is granted to the petitioner to argue all these points before the court below at the appropriate stage. With this liberty, the petitioner is disposed of. Yes, next.
19.
Please, my lord, in this case, matter has been amicably settled between the parties. By misappropriation of 1,05,000 some odd, he has already paid that amount to the complainant company, and
who is for company?
I am for the informant, my lord.
Where is who is
They have not come.
They have
Date
not
may be fixed. Both the party will appear before this honorable court.
Monday, Tuesday.
Obliged.
Okay.
Obliged.
Land counsel for the parties jointly submits that the parties have settled the dispute. The disputed amount has already been paid to the complainant company. Leaves the matter uncertain. Yes.
20.
Can see the prayer.
Praise for expeditious hearing of the vigilance case minus pending before the additional session was Bhubaneswar. Since
2004 FIR.
Allah. All the dates fix kare apan कहते hearing charge from
Your prayer is only for expeditious.
My lord.
Right. The petitioner has invoked the inherent jurisdiction of this court under section 482 CRPC, inter alia seeking a direction to the court below for expeditious disposal of the trial in TR case number 10 of 2011, arising out of VGR number 26 of 2024. The next program, the present case is arising out of an FIR registered on 13/9/2004. When the charge sheet was filed, the charge sheet was although filed on
13/9/2004.
Charge sheet
13/9/2004. That's it file. Charge frame 22/8/2023.
First information is 13/9/2004. Charge sheet I am talking about.
Charge sheet is filed
Same day.
No.
When you
are asking for expediency, at least these things you should keep on searching now.
Charge sheet copy.
Charge sheet has not been filed.
Nah, charge sheet copy Kintu charge frame it was delayed due to the delay attributed to the
charge sheet has
accused
been
persons.
filed.
In the meantime, and the charge was framed
Subsequently on 22/8/2023, charges have been framed. Charges have been framed. 23 charges have been framed.
23.
No, man.
Charge frame 23.
September 2023.
September 22, 2023.
How many witnesses? Nothing is there.
45 witnesses.
2023, the charge has been framed. 45 witnesses are there.
No witness has been examined.
I know that, therefore you are here. How can I target it now? When leaving every work, it has to be done. Your work only to be done. You don't know when the charge sheet was filed. You tell me the charge sheet was filed when. Then I can say that delay is attributable to them. You don't assist anything and you want everything.
Court will let in charge sheet.
Right on. Charge sheet file. The prayer is made before this court that a direction should be issued to the trial court for expeditious disposal of the trial. No doubt the petitioner has constitutional and statutory right of a speedy trial, free, fair and speedy trial. However, since the charges have been framed only on 22/8/2023, and it is stated at the bar that there are 45 witnesses.
And delay is attributed to the
witnesses.
accused persons.
Witness, it may not be appropriate for this court to target the trial. Moreover, whether the delay is attributable to the accused or not is not emanating from the record. Therefore, I'm not inclined to pass a specific order targeting the trial. However, we suffice to say that the trial court shall do well to see that the trial is proceeded as expeditiously as possible. With this observation, the petition is disposed of. All these things happened because you have not said anything. Still, I have given this. Yes. Yes.
21. May I please? Your Lordship?
Sentence.
My Lord, 4 years.
4 years.
4 years for 409 and 4 years for 13(2) of PC Act.
Undergone. How much?
My Lord, in fact, he was 4 days in custody prior to trial and subsequently.
We'll admit. Relation file date and so far as bail is concerned, the petitioner during the period of trial, he was in custody for about 4 days.
4 days.
No, from the date of judgment, 13/8, he is in judicial custody because of sentence of 4 years. From the date of judgment, 13/8.
Right. After the judgment, the impugned judgment was passed on
13/8/2024.
Since the sentence was more than 3 years, the petitioner was taken, the appellant was taken into custody. The hearing of the appeal will take considerable time. In view thereof, bail is granted. Okay.
Name may be
Bail granted, LCR called for.
Name may be reflected on the top of the brief
same.
and as well as cause list.
And sterilization of file.
Realization state, bail granted and everything.
Yeah.
Yes. Next.
22.
Yes.
2 years.
2 years.
2 years.
Realization of a fine state, bail granted, admit, and LCR called for. Same.
Copy in course of the bench.
Copy will you get in course or the bail court? Less than 2 years, yes.
Free copy will be given.
Yes, cash. Load.
Uploaded.
I don't. He counted.
Yes, sir.
There is no
Ask my
right on at the instance of opposite party number 2, FIR number so came to be registered against the allegation against the petitioner is so. Charge sheet was filed?
No, my lord.
Who has relegated you to the mediation?
In ABLPL number, page 17 also you can.
And by the order of this court?
This one I will put in anticipatory bail application.
Okay.
That
When
is
the
page 17.
petitioner's anticipatory bail application was pending, the matter was referred to mediation.
Money.
And during in the mediation, the parties have successfully settled their dispute. Mediation report is placed on record. The parties have decided that the petitioner shall pay 10 lakh rupees towards full and final settlement. 8 lakh rupees was already paid to the petitioner, and today the petitioner has paid another 2 lakh rupees by case to the opposite party number 2 in the court. The petitioner and opposite party are present in the court, being represented by the respective counsels and identified by them. They have also filed the self-attested copies of their Aadhaar card, which is taken on record to establish their identity.
They were given
the mediation report is taken on record. The opposite party number 2 has also filed an affidavit dated dated series charges are 24. Inter we are stating that they have settled the issue. C has received the entire settlement amount, and C doesn't want to prosecute the petitioner anymore, in view of the aforementioned, the FIR and consequential proceedings. So yes.
voter ID card खाली द्यायचे, Aadhaar card.
Aadhaar card जाकर voter card देंगे.
Obligation.
Are you sure that you are giving the money to right person? Who
Yes,
is
sir.
appearing for opposite party?
I am appearing.
Sure that.
Ismail,
Yes.
She also present, madam.
23.
May I please, Your Lordship? My lord, the case is under section 20B2C of the NDPS Act, my lord.
Yes, sir.
And the petitioner is aged about 18 years boy, my lord. And the date of occurrence 1-10-2023, and he is arrested at the spot. An allegation against the present petitioner.
Recovery, how much?
88 kg, 200, man.
88 kg, my.
18 years.
Antecedent? Antecedents.
There is no antecedent. Antecedent, no antecedent, my lord. It was not yet received.
Not even 1 year.
Not even 1 year. My lord,
October,
1 year.
keep it till October. October I'll give you. Yes. 1 year. Standard 1 year, less than 100. Yes.
Please, my lord. My lord, here.
LCR was called for. LCR is there.
My lord, final PR report is there.
Huh?
PR report is there, my lord.
LCR called for LCR. Sorry, LCR बोल रहा हूँ. CD.
See, I have also given the copy of the deposition.
No, I am not talking about your case, the earlier one.
Sorry. Yes. My lord, basing on an allegation dated 11/3 to, sorry.
Custody, you tell me custody.
Custody, my lord, since 11/3/2022.
11/3/22.
22, sir.
Okay. CD is there?
Yes, man.
Yes. My lord, basing on an allegation on 28/8/2016, a case under section 302 read with a 201 has been registered against the present petition.
Tell me the allegation against.
There.
But he has killed his father-in-law.
How?
Father-in-law.
Father-in-law.
Okay.
That
How?
There is multiple injury on the slab.
How he has killed, involvement.
And injury, 8 numbers of injuries is there, body, my.
What is the recover from him?
No, madam, nothing.
Any eyewitness?
No, eyewitness was there. But my lord, last scene theory is there.
Basing
One
on
Tukuna Barik, he has seen. Then both the present petitioner and deceased, they were. But he was examined as PW11.
Already examined.
But he turned hostile. And another, my lord, informant is PW3, my lord. Kindly see PW3. And another is villager Turijodhana Sethi. He is PW6. PW3, my lord, para 4, my lord, kindly.
Yes. PW3. Okay.
Who is the informant?
Who is informant?
Well, Robin
amicably settled.
No, my lord, then, my lord, the accused brought back his wife from the house of the deceased to their house at Sattakhanda.
Who is he?
My lord, he is the brother, my lord.
Brother of the deceased.
Brother of the deceased. Yes.
Brother of the deceased. Okay. Yes. The accused has brought back his wife from the house of the deceased.
Then, my lord, para 4.
Again, repeated. On the request of the parents of the accused, this is what do you want to show?
Well, para 4, my lord. The deceased and the accused decided to take a house on rent and finalized to take rent the house of promotion and parent. The accused lived with Bonita peacefully for 2 to 3 months. Bonita is the married wife.
Yes.
The accused again assaulted Bonita being intoxicated. Bonita went to her home and went to her parents. The accused went to house of the deceased at night, and with the deceased went back to her house at Puruna Katak. When the deceased did not return home, Duryodhana Sethi, our cousin brother, saw him. He saw blood stain at the house of Niranjan Sethi. He found the dead body of the deceased dipped in mud at the backside of government hospital, Puruna Katak.
The Niranjan Sethi is the accused.
Niranjan Sethi is the present petitioner. He is the accused, my lord.
The
blood stain was in his baranda, my lord.
Have you verified whether that is a human blood stain, whatever?
But the chemical examination report, it was awaited.
The dead body was recovered in the very next day, but he was missing. The dead body was recovered in the very next day in the back
behind the hospital.
Yes, behind the hospital, and no one has seen
what else is there?
My lord, That blood stain was there in the veranda of the present.
Trial. Except that, what you have?
Nothing. My lord, other material witness that the wife, other statement is there, though they were not yet examined. Wife of the present petitioner, and my lord, the father of the present petitioner. Their 161 statement was recorded, but they were not.
What wife says?
My lord, wife.
Because the wife statement is very important.
Wife says, my lord,
where is that? Right. PW?
She was not yet examined.
Not yet examined.
No. And father of the petitioner also not yet examined.
Father of the petitioner is not more important.
Because he has stated.
Because her father has been killed.
Her father, yes.
So whether she is alleging against her, right now, we wait till the.
My lord, the incident of 2016, out of 20 witnesses, 8 witnesses only examined. 9 years in the meantime, 9 years has already been elapsed. Any stringent condition may be imposed, and so
you were in custody since
11/3/2022. Sir.
You got bail earlier, what?
No.
You are absconding.
No, they
yes, charge sheet submitted showing him as absconding.
Then, right now, petitioner is accused and also out of how many charge sheet witnesses?
20.
Out of 20 charge sheeted witnesses, 10 witnesses.
8 witnesses only.
10 witnesses have already been examined. However, the vital witness, namely the wife of the petitioner, who is the daughter of the deceased, has not yet been examined. Therefore, I am not inclined to enlarge the petitioner on bail at this stage. However, liberty is granted to the petitioner to renew his bail plea after the examination of the daughter of the deceased. And petitioner is also granted liberty to renew his bail plea after 6 months if the material witnesses are not examined. With this liberty, the petitioner is disposed. Yes, next.
25.
May I please? Inside custody from 24/6/2023, my lord.
Yes.
And
custody?
24/6/2023.
24
June 23.
23, yes. Offense
302, my lords.
302.
The allegation is that, my lords, the deceased.
CD is there?
Yes.
Petitioner has given some money to the deceased and asked for how you spent. And there is some quarrel, and he pelted a stone to her, and he died. She died, my lord.
Sorry, pelted a
stone.
My
lord. But the thing is that no eyewitness and no one has said anything.
Eyewitness is there.
Who is there? Eyewitness?
Bhagavati Bagh.
Read Bhagavati.
That.
Read. ମୁଁ ଭଗବତୀ କିଶନ ଅଶୋକ କିଶନଙ୍କୁ ବହୁତ ଭଲ ଭାବରେ ଜାଣେ ଏବେ ସେମାନେ
and the trial court is directed to examine the eyewitness and other material witnesses preferentially giving preference over the formal witnesses and petitioner is also given liberty to renew his bail after 6 months if the material witnesses could not be examined for any reason whatsoever. Yes. Next.
26.
Yes.
My lord, on behalf of my senior Mr. Sushant Kumar Joshi, I pray for a Passover.
No Passover, adjourned after 2 weeks. Yes.
27.
27, my lord, the petition is custody from 10th September 23, about 1 year.
10
September 23.
23, okay. Yes.
The offenses under section, my lord, 373, 372, and 506, and section 6 of the POCSO Act, my lord.
Okay.
But fact is that both the victim and the petitioner.
373.
I am appearing.
You are there. Yes, sir.
Both the petitioner and victim are the same village, and they are the in front of the house. And the front to front, opposite.
Show me 164. Show me 164. Do you have?
No.
No.
I am reading a very relevant portion, page 27, Lord, so kindly see.
Uh-huh.
Last 4 lines.
The
medical report of the victim shows that she had sustained injuries on her private part as there was fear of human.
Yes.
My lord, I am for the informant. My lord, so prosecution has examined already 11 witnesses. Out of 13 witnesses, IO has been examined. Victim has been examined, informant has been examined.
Yes, madam, then what is the hurry? Now, 313 statement will be recorded and if you are acquitted.
Lordship, Lordship, the IO has not yet been examined.
My lords,
He says
IO has been examined on 3/4/2024 as a PW11, my lord.
Lordship, the defense has not examined the IO. The defense has declined in the meantime, and filed a recall petition for examination of the IO.
The prosecution, the defense is delaying the matter. Your lordship may target.
Okay, 3 months. Better. Petitioner is agreed by the order dated. Where is that order? Your bail application rejected when?
No, let's.
Order dated 25/1/2024, whereby his bail application has been rejected. Notice was issued to the opposite party, number 2, victim. Victim, you are the victim or informant? You are appearing for informant or victim?
My lord's informant, mother of the victim.
Informant. And Mr. Bhui, legal counsel for the informant opposite party, submits that the trial is at the taken. Even the IO of the case has already been examined. Mrs. Panigirai, legal counsel for the petitioner, submits that although the IO has been examined, but the defense has not cross-examined the IO as yet. In view of the fact that the trial is taken, I am not inclined to entertain the bail application in this case. Therefore, the bail application is rejected. However, liberty is granted to the petitioner to renew the bail plea after 3 months. After 3 months, if the trial is not proceeded at the expected pace. With this observation, the petition is post. Yes.
My lord's defense will be directed.
3 months. I have given 3 months target.
My lord's defense may be directed to cooperate.
Lordship, I have been
If they don't cooperate, then they will not get bail. 3 months I have given. That's their outlook.
Lordship, I have.
It is expected that the defense shall not unnecessary prolong the trial prolong the trial and cooperate with the
Lordship, the defense is cooperating the prosecution. That's why he has filed the recall petition. But the IO is not present in the meantime. What is the fault of the defense?
Defense.
3 months target I have given. It will be done. Yes. Next.
29.
This is a modification
of the month of March, Lordship. But due to adjournment, it became difficult for a lordship to hear the petition. Just because this is a UTP record and remand period is 15 days. In the meantime, all the witnesses.
He is saying something, don't disconnect like that. Some lawyer is saying something, never disconnect like this. This is very bad manners. If somebody is saying something, how can you, who has stopped it? But if you have not done it, it's all right. But whenever some lawyer is speaking, never even disconnect. Because some relevant thing he might be or he might be saying. Yes, madam, what do you say?
Lordship, this present petitioner has filed a petition in the month of March, but due to adjournment of the petition, it became difficult for your lordship to hear the petition just because this is a UTP record and remand period is only 15 days. In the meantime, all the witnesses have been examined, but the IO has not yet examined because the IO is not produced in the court.
The examination chief of IO has already been over, and he has to be cross-examined by you. So therefore, I have fixed 3 months target. I think it will be done. If it doesn't happen, then you can renew your bail, please. Okay.
Yes, this is a modification application as the IO has submitted the charge sheet in the name of Manoj Dara instead of A. Manoj Dara, for which
there is a problem. Bail order has been
granted for
bail has
22
been
days.
granted because A is missing.
A is missing. Same person.
Same person. Clarified.
Yes.
That clarification I was asked today morning also, I asked that I will type it, I will give you. So he has not till now, he has not sent it.
See, in the charge sheet, you have filed Manoj Dora.
Yes.
Manoj Dora. In another case,
Another case, it is
A Manoj Dora.
He is A Manoj Dora. Right on. The petitioner, in the present case, the petitioner has already been enlarged on bail by the order dated 6/8/2024, isn't it?
Yes, madam.
Due to the confusion in his name, the benefit of the bail order dated 6/8/2024 has not been availed, could not have been availed by him. Land Council for the petitioner submits that his name is in fact A Manoj Dora, whereas the charge sheet has been filed
Manoj Dora.
as Manoj Dora. As Manoj Dora. He is accused in another case where his charge sheet is filed stating his name to be A Manoj Dora. A Manoj Dora. Notice was issued to the state for instruction regarding the same. Instructions regarding the same. It is apparent from the charge sheet that the name of the petitioner has been written as Manoj Dora instead of A Manoj Dora. A Manoj Dora. A Manoj Dora. Therefore the I can't in fact correct the charge sheet.
No, your lordship may say that it's the same person. As the petitioner is also saying that in my name also the A Manoj.
But I mean, in this case, he has to file an affidavit before the court. T Manoj Dora and Manoj Dora same.
Already filed.
That may be reflected.
Already filed in the court, and he has.
Okay. In view of aforementioned, he's Mr. Ragada is correct. You have to file affidavit.
Already filed, my lord.
A Manoj Dora and
Manoj Dora
the same.
Already filed, my lord. Along with the affidavit, I have already filed. It has not been considered by the London court below.
That will take into consideration.
For the petition submits. He has already filed an affidavit before the trial court, interiorly stating that A Manoj Dora and Manoj Dora is one and the same person. However, the trial court has not considered the same and granted the benefit of the bail order dated 6/8/2024 passed by this court. Taking into consideration regard being had to the aforementioned submission made by the parties at the bar.
Other name also.
It is directed that the trial court shall consider the affidavit filed by the petitioner and
petitioner's mother, my lord.
Petitioner's mother and pass appropriate order. With this observation,
My lord, the case has been independently committed to the additional special judge vigilance. Come additional session judge in city.
In session I have written, no problem.
Yes.
Yes. Next. Yes. Yes, sir.
Wait, please, Lord.
Yes.
This is an allegation under section 376(2)(n), 363, and other alleged offences, and section 6 of the POCSO. The present petitioner is in custody since 10/10/2023.
10/10/2023. Okay. Charge sheet has been filed?
Charge sheet has been filed, trial has already commenced, and victim has already been examined, and I have filed the deposition copy, and it is at...
Where is that deposition?
Flag C.
Okay.
Certified copy of...
Read that deposition of the victim.
My lord, she has supported.
Supported the prosecution?
My lord, she has supported the prosecution.
Then
my lord,
what can I do for you?
My lord, my grounds. My humble submission is that, my lord, the incident took place on 7/1/2023. The FIR was registered after a month. 7/1/23, date of occurrence. FIR was registered on 11/2/2023, after more than 1 month. Second of all, my lord, if your lordship may kindly have a glance at the medical examination, she has stated that as per the statement of the victim girl, she is in love affair with the said accused. Since 1 year, they were willingly keeping regular sexual intercourse. The age of the petitioner is 21 years, my lord.
23 years.
I'm sorry, my lord. 23 years.
First I see that only.
I'm sorry. 23 years, and it was a love relationship.
Yes,
And-
17 years. The girl is 17 years.
My lord. And if your lordship may kindly permit me to place the statement of the person in whose residence these two, the petition as well as
Last 6 months it is pending. Once your lordship grant bail to the principal accused, there is every probability there will be no conclusion of the trial or investigation.
He is principal accused.
He is the principal accused. Petitioner is the principal accused. Father and mother are also absconding. Once their bail application, anticipatory bail application was refused, that's why he withdrew. Subsequently, now it is pending since February 2024.
He is the husband, huh?
No, present petitioner is the husband.
my lord.
Anticipatory bail of the father-in-law, mother are pending. Petitioner's father and mother, they are pending. And once it was withdrawn, others were granted bail because there are prima facie material found against them. The Honorable Court was not inclined to grant bail. Now it is pending since February, my lord. I have checked out.
The mother-in-law.
Mother-in-law and father.
What are the overtake attributed to him?
Overtake, my lord.
My lord.
In the charge sheet, show me the charge sheet.
Charge sheet, my lord.
306 or 306?
306, my lord. 306.
How the girl has died?
Suicide, my lord. Suicide.
Suicide to I don't-
Consistent demand of dowry and
Yes.
under influence of
Bolted the door
liquor.
from inside. Anything?
No, my lord.
One
That's-
child.
I permit to place the statement of one independent witness, my lord.
Yes.
One child.
That's it.
Living with one child of 1 year.
ଆଜି ମୁଁ ଆପଣ ନିକଟରେ ଜବାନମାନ ଦେଉଅଛି କଷ୍ଟଡି ସିନ୍ସ ମାଇଲା 4/10/2023
4/10.
yes ma'am
23.
yes ମୁଁ ଆପଣ ନିକଟରେ ଜବାନମାନ ଦେଉଅଛି କି ଯେ ଆମ ଗଳି ରହୁଥିବା ଦିବାକର ଦାସ ଆମର ପଡୋଶୀ ଅଟନ୍ତି ଗତ 1/12/2021 ତାରିଖ ଦିନ ତାଙ୍କ ପୁଅ ଜନ୍ମେଜ ଦାସଙ୍କ ବାହାଘର ପୁରୀହାଟ ଥାନା ଅନ୍ତର୍ଗତ
Come to the relevant part.
ଗତ 2/10/2023 ତାରିଖ ଦିନ ସକାଳେ ମୁଁ ଘରେ ଥିବା ସମୟରେ ଦିବାକର ବାବୁ ଆମ ଘରକୁ ଆସି କହିଲେ କି ତାଙ୍କ ବୋହୂ କୌଶଲ୍ୟା ଘରୁ ରାଗି ତା ବାପା ଘରକୁ ଯିବାକୁ ଜିଦ୍ ଧରିଛି ସେ ଦାଦା କାଳନ୍ଦୀ ବାବୁଙ୍କ ଫୋନ ନମ୍ବର ମାଗିଲେ ମୋର ଦିଅର କାଳନ୍ଦୀ ବାବୁଙ୍କର ଫୋନ ନମ୍ବର ଦେବାରୁ ସେ ନେଇ ଚାଲିଗଲେ ସେଇଦିନ ସନ୍ଧ୍ୟା ବେଳକୁ କାଳନ୍ଦୀ ବାବୁ ଦିବାକର ବେହେରାଙ୍କ ଘରକୁ ଆସି ପହଞ୍ଚି ମୋତେ ତାଙ୍କ ଘରକୁ ଯିବାକୁ ଡାକିଲେ ତେଣୁ ମୁଁ ମୋ ଦିଅର ମହେଶ ତାଙ୍କ ଘରକୁ ଗଲୁ ଆଲୋଚନା କରୁଥିବା ସମୟରେ କୌଶଲ୍ୟା ଡିସିଟ୍ ଭୀଷଣ ଭାବେ ରାଗି ଯାଉଥିଲେ ସେ କାହାରି କଥା କିଛି ଶୁଣିବାକୁ ରାଜି ନଥିଲେ ସେ ମଧ୍ୟ ରାତ୍ରିରେ ତାଙ୍କ ବାପା ଘରକୁ ଯିବାକୁ ଜିଦ୍ ଧରୁଥିଲେ ମାତ୍ର କାଳନ୍ଦୀ ତାଙ୍କୁ ବୁଝେଇକି କହିଲେ ସକାଳୁ ତାଙ୍କ ବାପା ମାଆଙ୍କୁ ଡାକିଦେବେ ବାପା ମା ଆସିଲେ ତାଙ୍କ ସହିତ ତାଙ୍କ ଘରକୁ ପଳାଇଯିବେ
Morning she was found.
yes ma'am ଏପରି ବୁଝାବୁଝି କରି ଆମେ ସେଦିନ ସକାଳୁ ଘରକୁ ପଳେଇ ଆସିଲୁ
Just see, it is bolted from inside. She has committed or do you have anything?
no my lord they say no
Suggest. Yes. Anything to suggest?
Preliminary charge sheet is filed, but final charge sheet.
Preliminary, because the father-in-law and
Mother-in-law are yet to be arrested.
When the anticipatory bail is
My lord, first anticipatory bail was withdrawn.
forget about when it is listed now.
Now it is pending before Honorable Singh coordinate bench, my lord.
When it is listed, do you have any?
It was no, my lord. It was never listed, my lord. He has not tried again.
Many
Many cases
there's a
are
problem
listed.
there's not listed my lord in the meantime other
Many
three are granted anticipatory my lord
No, they have nothing to do. You know,
Husband, you are the principal accused. Yes. Husband.
They
The
are
problem,
normal
I'm
minds.
bit worried if, because the other, if I pass some order, then it will influence that anticipatory bail also.
anticipatory is pending before the
Right, Learned Counsel for the opposite party submits that the co-accused, namely the father and mother of the present petitioner, has applied for the anticipatory bail, which is pending before this court, pending this court. In view of the fact that the anticipatory bail application of the co-accused persons are pending, the present matter is urgent to put it after the 4th of October, because he is in custody from 4/10/2023. Or 4th October पर डेट दीजिए, हाँ डेट दीजिए. By that time you get the anticipatory and see 1 year will be completed on 4th October. I am guaranteeing bail on that.
I am also trying to get it listed.
Yes. Before that,
My
you do
only
it so that
endeavor is, my lord, let
the
the trial
worry-
be
the worry
concluded.
is if I pass an order that will influence the.
They are appearing in many cases other side, my lord. My entire endeavor is the let the trial
But
be completed.
I am making it very clear that on next date appearing, I am granting the bail.
Yeah, obliged. I am
Without
also
any-
trying to get it listed.
Right.
August.
Least and fifth, sixth, fifth or huh? Seventh Monday. What about fourth? Fourth, you least and fourth.
May I please, your lords?
32. 32. Yes.
Rejection in 5th February 2024. Charge sheet was filed on 8th March 2024.
Rejection on?
Rejection on 5th February 2024.
Huh?
And charge sheet was filed 8th March 2024.
Then you go, sir. Madam, petition is agreed by the order dated 5/2/2024 for 24, whereby his bail plea has been rejected. Subsequent thereto on 8/3/2024, charge sheet has been filed.
May I
Bail plea was rejected during the period of investigation, and subsequently charge sheet has been filed. The petitioner is granted liberty to renew his bail plea in the court of
my humble submission.
I'm not inclined to entertain the present.
May I pray one thing, your lordship? In this case, the petitioner number 1, the principal accused, madam, and the petitioner number 2 and 3, they are the friend of the accused, madam.
Anyway, you get it, no, otherwise you straight away you come here.
On that ground, madam, I will submit before the Lennon court below. That liberty.
What do you say? What do you say?
Petitioner number 2, 3 are the friend of the accused, madam.
And all three came.
All three.
Possibly took away the guard.
This is a murder case, na?
No.
What is this?
376, the age of the.
Who is the principal accused?
Petitioner number 1, madam.
Why should I tell anything that will prejudice petitioner number 1? You may, 2 and 3 may get the bail. Unnecessary because of observation, he will get that. But don't do that.
Madam.
Don't do that. It's better. If I say that he is the principal accused, on that ground the trial court will get. Why to create problem for him? Leave it like that and you get the bail. No problem. Yes. Yes, sir. Why this is
Notice was issued.
Huh?
Notice was issued.
Aye.
376.
What week? Huh? What did he ask? Huh? 9/8? 9/8/24. Non-APS for the petitioner in the interest of justice. Why is he asking for? Let us see recalling. I have already disposed of this matter.
Yes, sir.
Petitioner engaged Naik advocate in the aborted case. Engaged counsel.
High Court also not solved to the state.
Petitioner came to know that 2 orders have been passed in his absence. The Vakalatnama of his Naik advocate was not placed in the court on so for which he is not able to appear and argue the matter. Oh, there is nothing right now. The 1056, non-APS for the applicant. The present matter has already been disposed of by the order dated 9/8/2024. Granting liberty to the petitioner to renew the bail plea before trial court. The petitioner has moved now the application seeking the recall of said order on the ground that on the date when the order was passed, due to confusion, the advocate whose Vakalatnama is on record has could not present his case. Present his case. When the matter is taken up today, none appears. Since the order dated by order dated 9/8/2024, this court has only relegated the petitioner to move the trial court for grant of bail. No prejudice is no prejudice. The application moved by the petitioner is devoid of merit, and I am not inclined to entertain this. Yes. Yes. Yes.
34.
May it please your lordship. Your lordship, recalls, my lord, this is not a usual case of 376. A 47-year-old lady, my lord, he alleges that the petitioner raped her. And the medical examination report, my lord, which was conducted on the very next date, it is silent about the allegation, my lord. Your lordship, may kindly see page 72, the medical examination report. I have annexed, your lordship.
22.
72.
Yes.
I'm sorry, my lord, 59, 59, 59, my lord.
59. Medical evidence?
Yes, your lordship. 59, it starts, and the relevant portion, my lord, it is there at page 72. 72.
72,
my lord. Lordship, got it, my lord? 72.
Yes.
My lord, there are points 1, 2, 3, 4, 5. Your lordship would find there are no bodily injuries on her person suggesting forcible sexual intercourse. Her clothing has no physical clue.
The petitioner has criminal antecedent. Pursuant thereto, the last on the last date of hearing, a direction was issued to the petitioner to file an affidavit. The petitioner has filed an affidavit stating that there are two criminal cases. There were two criminal cases filed against the petitioner, being these two cases. In both the cases, the petitioner has already been acquitted. The affidavit is taken on record. Taking into consideration the nature of allegation and period of custody, I am inclined to grant the petitioner, inclined to enlarge the petitioner on bail, subject to the condition being in proper and further condition that the petitioner shall appear before the court below on each date of hearing without fail. Secondly, he shall not be in contact with the victim or the family member of the victim in any manner whatsoever. And it is also made clear that if it is found by the trial court that except these the two cases which have been disclosed by the petitioner, if any other case is pending against the petitioner as of today, then the concession of bail granted to the petitioner shall be withdrawn. The next paragraph, the condition imposed by this court or the court below is violated. The prosecution is given liberty to move the application of the trial court for recalling of the concession granted by this court. If such application is moved, the same shall be considered on its merits. Yes.
But I may be permitted to withdraw my lord.
Very good. Withdraw. Yes.
36.
Lordship, item number 36.
Yes.
Lordship, on behalf of Mr. Chand, Lordship, praying for adjournment, Lordship.
Adjournment. October, but it will go to October. Okay. Yes.
38.
38.
I permitted to withdraw my lord.
Permitted, yes, withdraw. Sir is waiting for which matter?
I'm just asking whether that matter, part heard matter, item 69, that vigilance matters. My lord, at last time 60 at 2 o'clock. If my lord has matters, my lord can finish. I have one small matter, I'll finish and come back.
69 is the agenda? It's not urgent, no? It's not urgent. Then, okay, you make up.
My lord can take, after my lord finishes the
Yes,
bail matter.
I'll finish the board bail matter. Yes.
Can I come back when around 2:30, 2:45?
Yes, yes, no problem. You can come, no problem. Yes.
39.
Item 39, my lord, pray for tomorrow, my lord.
Tomorrow,
my lord.
Thank you. You didn't ask today in midnight. Urgent to October.
Item 40.
October, all October. Anybody is asking for adjournment? October.
Next week, one.
In the morning, there are many people standing in the queue to get their bail application heard. You get an opportunity, you are asking for adjournment. It will go to October. What to do?
Next week.
No, nothing doing. Nothing doing.
Pass.
October last. No. Next, 40.
40.
Non-APS.
My lord, Passover 39.
Passover is also not possible. Non-APS in the interest of justice urgent. Yes.
41.
41 may I preach?
Yes.
41.
Yes.
Lordship. The
Yes.
petitioner before your
Custody?
lordship in custody since 8th August 2023.
8/23. Okay.
Lordship.
Yes. Tell me what is the
The offense alleged are your lordship, that is 376, 376 2 and 376 3 as well as 6 of
notice was
POCSO.
issued?
Yes, your lordship.
Who is appearing? Service before? Anybody is appearing?
I have filed since
Yes, see the service.
22nd April 2024.
Service on opposite party number 2 is still awaited. Still awaited. Lease the matter. Awaiting service. Next.
May I pray your lordship for a short period? In the meantime, I will
Already
track the
in
track
between.
report also.
Adjust the list and give it. Yes.
52.
Obliged.
Yes, sir.
My lord, the present petitioner custody since, my lord,
Yes.
6/8/2022, my lord. The present petitioner custody since 6/8/2022.
6/8/23.
2, my lord.
22.
Yes, my lord, more
Okay.
than 2 years, my lord.
Okay. Yes.
FIR under section, my lord, 441, 376 2N and 376 3, my lord.
Yes.
Charge sheet file on my lord,
What are the
5/10/2022.
allegation you tell me? Don't tell the
Allegation, my lord, the present. Jai.
376 AB is there also.
AB also not see.
Final charge sheet is filed.
Yes,
Charge
madam.
sheet filed, madam.
Hmm.
Charge sheet
Annex
filed,
of two,
and
madam.
out of 14 witnesses, 9 witnesses have already been examined in the
Okay.
perhaps other witnesses are turned up the exact status of the case.
Show me the evidence of the prosecutrix.
My lord, that is not there, but after rejection order, it has been
After rejection order.
rejection order shows that 14 witnesses out of 14, 9 witnesses have already been examined. Madam.
Show me the evidence of prosecutrix.
My lord, next year I will supply, my lord.
Then counsel for the
AB is there, notice has to go to the.
notice has already been issued, no? Huh? Requisite is not filed.
Ah.
Despite the fact that notice has already been issued to the opposite party number 2, necessary requisites have not been filed. Therefore, notice could not be issued. The petitioner is directed to file requisites within 2 weeks. Please the matter in the end of October. Yes.
Obliged, my lord.
Okay. 44, man, pray for 1 week after to obtain some.
Agent, on the request agent. Yes.
45.
Obliged.
Yes.
In this case, the charge sheet is submitted on section 498A. Right. 498A, 34 IPC, and 4 of Dowry Provision Act, and on section 306 of Indian Penal Code.
Yes.
The petitioner
Custody
before
since-
my,
Custody?
is in custody, 14/1/2024.
24. Okay.
Minor.
You are the husband?
Petitioner is the husband, my lord.
Assuming.
Tax sheet was submitted on
That is 9/6/24, my lord. Just I have received the CD, my
my
lord.
lord.
9/6/24, that is 498, 34, 4.
And rejection order?
Rejection order.
You have not filed anything. Wow.
Yes,
Where
yeah,
from
but
will get right?
I filed, my lord. In the rejection order.
9/6/24.
Yes, my lord.
Or then you have to go to trial court, right on. Petitioner is agreed by the order dated 19/2/24, whereby his bail application has been rejected. Subsequent thereto, on 9/6/2024, the charge sheet has been filed. Since the bail plea of the petitioner was rejected and during the investigation period, and the subsequently charge sheet has been filed, petitioner shall approach the court of first instance by renewing his bail plea. I am not inclined to entertain the bail plea of the petitioner at this stage. However, liberty is granted to petitioner to renew his bail plea before the trial. With this information, yes. Next.
46.
Yes.
The nephew of the deceased. He is in custody since February 2023, my lord. Sorry, October 2023, 9/10.
Date.
9/10/2023.
9/10.
2023.
Yes.
He is the nephew of the deceased. Allegation, my lord, there was a civil dispute in their family. The wife of the deceased lodged a complaint alleging that
CD is there, sir?
Yes, yes, my lord. CD is
Yes.
there.
it is making complaint that yesterday, I mean, the occurrence took place on 7th October. On 6th October, he is a betel shop owner. After closing this betel shop, he had come to take a dinner. After that, he went to the shop for sleeping, my lord. And subsequent, on next day morning, the wife found that dead body was lying in the backside
What
of
are
the.
what are the evidence?
My against me, my lord, 27 evidence act is
27 is there.
only 27 evidence.
ଦାଦା ବୀର ବରାଳ ତାର ଦୋକାନ ପାଖରୁ ଆସି ମତେ
What is the stage of the
Investigation concluded.
and
It's-
charge has been filled?
Charge has been charge sheet under since 4/2/2020.
Charge has not yet been filled.
No. 4/2/2024.
You are in custody since 9/10.
9/10/2020.
Lease it on 15th October. 15th October. Give me that. With the bourse, huh? Yes.
After vacation. I'll give it.
Yes.
47.
Yes.
Item 47, I may permitted, my lord. Petitioner
Yes,
is in
sir.
custody. My lord, petitioner is in custody since 7/11/2023, my lord. That is
7/11?
2023, my lord. That
Yes.
is about 9 months inside custody, my lord. And charge sheet has been some investigation completed. Charge sheet has been submitted under section 377, 506 IPC and section 6 of the POCSO Act, my lord. My lord.
Charge sheet submitted on?
Charge sheet submitted 4/1/2024, my lord. 4/1/2024, the charge sheet date. 377, 506 and section 6 of POCSO. An allegation is that the petitioner was working as a peon in the hostel, my lord. And the victim is a 11-year-old boy, my lord. And the allegation is that the petitioner committed unnatural offense with the boy, my lord. And the medical examination report.
Very heinous allegation is there, my lord. The petitioner committed carnal intercourse with the minor victim boy in the hostel bathroom, which
Right, Lord.
age is
And
10 years now.
medical report.
Class 4.
Medical report, my lord.
I'm not inclined to. You are 29-year-old man and a
Because
small
of this
child
case,
of
my lord,
11 years.
lordship, I appreciate lordship sentiment, my lord. Thing is that, my lord, medical report, my lord, is totally silent, my lord. Lordship, kindly see that
After the
final
material
opinion. Final opinion, my lord.
Also regarding head to the nature of allegation against the petitioner. Allegation against the petitioner is also regarding head to the nature of allegations against the petitioner, I am not inclined to enlarge the petitioner on bail at this stage. However, liberty is granted to the petitioner to renew the bail plea after the material witnesses are examined. Since the petitioner has been in custody since 7/11/2023, the petitioner is also given liberty to renew the bail plea after the expiry of 6 months if the material witnesses could not be examined for any reason whatsoever. If such application is moved, the same shall be considered on its merits. Yes, next.
My lord, after examination of the victim, my lord.
Yes, I have said. Yes.
48. May I please, your lordship?
Yes.
My lord, I'm the husband, my lord. I'm in custody since 10 to 2024.
10 to
2024.
10 to 24.
Yes, my lord.
What are the allegations?
My wife consumed poison, my lord. Then she was rescued and sent hospital by the petitioner and his family members.
You are taken to
Yes,
hospital?
yes, my lord.
Yes.
Yes. During treatment, she died.
After how many days?
How many, my lord? 14 days.
After 14 days.
Yes.
Any statement of the victim recorded?
My lord, that complainant statement is there, my lord.
No complainant. The victim remained in the hospital for 14 days. Have you taken any statement?
Update case there is not there, my lord.
Next week,
My lord.
awaiting update case diary next week. See, if you have not recorded the statement of the victim for 14 days, he is entitled to bail. Yes, next.
Date may be fixed, my lord.
Next week.
Date may be fixed, my lord.
Now he'll fix it. Yes.
Yes, okay.
Yes, madam.
Petitioner was released on interim bail for 2 weeks. The surrender certificate I filed, my lords, it's on record.
Yes.
My lords, a fresh file has been filed.
302.
My lords, 302. He's
Now,
been
just now you were out for some time.
My lords.
So wait. Go October last week.
CD.
Well,
My lords have been passed
the
over.
petitioner was on interim bail. He has surrendered and filed the surrender certificate, which is taken on record. Release the matter for final hearing.
My lords, it may be passed over, my lords.
Wait, not possible. Yes.
50.
Lordship, item 50, Lordship, kindly pass over.
No passover. Either argue or otherwise adjourn.
Lordship, short adjournment.
Adjourn. Or the request adjourn. Huh? Another 50. Otherwise, you can't adjust the board. Yes.
Item 50, notice could not be issued.
See, notice could not be issued, sir, in this item 50.
Lordship.
Requisite filed.
Late file notice.
Not filed requisite.
Lordship,
Go to October then.
Lordship, I'll find.
Despite the notice was issued to the opposite party number 2, the petitioner has not filed the requisite. Therefore, notice could not be issued to opposite party number 2. Requisites may be filed within a week. Is the matter after. Yes.
May. 302 CD is required. 302 CD is required.
CD, call for CD, yes.
Earlier CD was called for, man.
CD call.
Short date the.
Let him get the CD, yes.
52.
52. Yes, sir.
Non-appeal.
Non-appeals for the petitioner in the interest of procedure. Yes.
53.
In the meantime, victim has been examined, my lord. Allegation of 376, 3 and other offences are there. And I'm giving the, my lord, the certified copy of the deposition of the victim.
What she has said?
She has stated against the
What to do?
the getting, my lord.
What to do now?
Young boy of 19 years, petitioner. And
Victim is 13 years girl, my lord.
He is 19 years.
Yes, he is 13 years.
as per apparent, 15 years.
He is eligible for 14, my lord. Victim is 13 years, my lord.
do this.
PW3.
Any part which will help you.
No.
Why are you showing me?
Because in the meantime, my lord, a young boy, my lords, I'm trying for the, if he will marry the girl.
No, cannot pursue 13 years. How?
No, 15, 16 years.
Before 18.
And admittedly, though, my lord, the victim is a minor, but this is the elopement and
She has said everything.
my lord. And relation is, my lord, with consent, my lord. Even if, my lord, the minor. That is what I want to. That is with consent, my lord. It is reviewed from the deposition.
That's right, but
With consent.
Medical reports.
Sexual intercourse with me on the 3 occasion on the pretext of getting married to me.
That is also.
How many witnesses are there? How many witnesses remain?
My lords, out of my lord.
You are in custody since?
I am in custody since, my lord.
Not even 1 year.
Let it be liable.
Simply urgent to October. We'll see.
My-
Simply urgent. The problem is the girl says that on the pretext of marriage, he is also 19 years.
He is a major Miller. He can vote.
What measure 19 years and 15 years children? October, wait till October. I'll grant you.
Deeply. No, already requisition is filed, my lord. Already requisition filed.
Despite it is non-appeals for opposite party number 2 in the interest of justice.
No, my lord. The requisite filed.
Since the requisite filed lately, the notice on the opposite party number 2 could not be served. Press notice, issue press notice to opposite party number 2, lead to matter.
May I please lordship, my lord, yesterday I mentioned, my lord, his father died, my lord, 24/8.
Yes. Verified.
Yes, that is
Verified?
correct. Correct, genuine.
2 minutes, give me. Where is the application? The
IIS, my lord.
application I number?
1092, my lord.
1094. Right on. 94. 92. Right on. Petitioner. The application, petitioner has moved the application for interim bail on the ground that his father has expired on 24/8/2024. Therefore, he seeks interim bail to attend the rituals. The State Council has verified the factum of verified the facts. The IIC Sayapatna has submitted a report inter alia stating that the father of the petitioner has expired on 24/8/2024. The written instruction is dated 27/8/2024. Given by IIC Jayapatna is taken on record. Regarding to the fact that the petitioner's father has expired on the 24th. The petitioner is trial court is directed to release the petitioner on the conditions as being fit and proper for the period of 15 days. 15 days, how much you tell?
1 month because
15. 1 month. 1 month. 1 month. 1 month. Subject to the condition that the petitioner shall surrender before the jail authorities immediately after the expiry of the period of interim bail and the other condition to be imposed by the trial court.
A date may be fixed, my lord. Date may
So that he will surrender, my lord.
Surrender, my lord.
The trial court will fix the date.
No, my lord, here, my lord.
Here, my lord. I will give the
Otherwise, my lord.
certificate.
1 month count and give a data. 1 month.
My lord, may a small play, my lord. This order may be uploaded, my lord.
Today itself.
No, London court may be directed to act upon the online copy, my lord.
Don't say all these things.
During course of
We can't control the board of the trial court.
No, yeah, other courts are also allowing, my lord.
They will do it, yes.
In course of the day, my lord.
55.
Madam, copy because of.
Yes, yes.
Oblige, oblige.
55.
Similar. Yesterday matter, my learned senior's client means the
As per
informant
directions, he had appear, your lordship record the statement and pass order.
compromise.
No, I didn't follow. What
As
had
victim
happened?
girl, as per direction, victim girl appeared today. Here, my lord, your lordship record the statement and pass appropriate order.
55.
Yes.
CD is not required in this case, my lord. Case is like this, my lord. Initially
376 2N.
2N, my lord.
POCSO is not.
That interim bail, he had got.
That's right. But
But petitioner had gone interim bail for marriage, my lord. After marriage, my lord, timely surrender. Thereafter, your lordship.
they married.
They have already married.
Right.
He has no objection.
Right. Which is the order? That this is the order, na?
1/7/2024, your lordship.
By the order dated 1/7/2024, the coordinated bench of this court has passed the following on. Pursuant to the aforesaid interim order, the petitioner was released and he got married with the victim girl. Married on?
1/7/2024.
Married on?
Married, my lord. On 3/7/2024.
The victim girl is present in the and subsequent thereto, the petitioner surrender before the jail authority on.
That date was not with me. After
expiry of the
After the
4
expiry
weeks.
of the interim orders, the petitioner surrender before the jail authority. You must tell from where, which date he is in custody. I must write it. ऐसे थोड़ी कुछ भी बोल दो. You want regular bail, you don't know when he surrender. What is this? You tell me the date at least, I'll write. I need to write. You are in custody from such day.
I will tell you that.
I don't know whether you are surrender or not.
Yes, surrender certificate is with you, lord.
You must be having that. You tell me when you surrender.
Flag mark it is also.
Everything I have to do, then why are you coming in? File the petition, I'll do it myself. I'll not sit in the court itself. This small assistance also you don't give. When you surrender, you'll keep on searching.
Your lordship, 2/8/2024, my lord.
2/8/2024. The victim is present in the court, being identified by the counsel appearing on her behalf. He is appearing.
Yes, yes.
Madam, by the self-attested photocopy of the Aadhaar card to establish her identity, which is taken on record. On query from the court, she states that in fact she has already married with the victim when already married with the petitioner when he was on interim bail. She further states that she doesn't have any objection if the petitioner is granted bail. Regarding to the aforementioned development and the fact that the petitioner has already married with the victim, and I'm inclined to enlarge the petitioner on bail. Accordingly, the petitioner shall be released on bail. Okay. Yes.
Item number 53 is already been called up by your lordship and it has been disposed of by your lordship today. 33.
Okay.
In my absence, your lordship passed order and disposed of.
I will record your. I will record your presence. What do you want?
I wanted to record my name and also hear this matter.
No. I have only said that you go to the trial court, renew your bail, please.
Your lordship may say on 4/9/2024, your lordship passed 2 orders. First order was passed that verify whether the fresh Vakalatnama has been filed or not. And the second order was that it was a disposal to go to trial court. So without hearing me, your lordship passed 2 orders. So I want the first order, which was passed.
You tell me one thing. How many lawyers will appear for the petitioner? Every day one Vakalatnama. When I called up the matter today, you were not there.
My lord, my name.
And
is
you can't come at your sweet pleasure any time and barge into the court and say that, hear me.
My lord, my name.
I have passed, rightly I passed the order. I realize what I did.
Kindly hear me. My name is not.
I have not passed any prejudicial order. I have only said that renew your bail plea. Because one lawyer comes and says that I am not appearing. The other lawyer files the wakalatnama, he doesn't appear. What will I do?
I have already complied the orders.
I am so sorry, sir. I passed the order. If you agree, you know the remedies.
I am appearing on behalf of the petitioners when the first lawyer has given his consent. So I appeared. From that day, I am appearing before lordship.
When the matter was called up, you were not there.
My name is does not appear, so I
what can I do?
Your lordship,
The other lawyer comes and says that I don't have any
myself is Akshay Kumar Naik. Myself is Akshay.
Why are you making such a big issue out of it? I have only said that renew your bail plea. If the bail is not granted, again you come. There is no res judicata. You can move any application.
It is a very fair case.
I know the trial court will appreciate that.
So whenever I have filed all the requisites to issue notice to the wife, that your lordship has not issued notice to the wife.
I have committed mistake. What?
I am not saying.
You know, if the court commits mistake, you know the remedy.
Sometimes
Sorry, I will not.
My lord.
I will record his name.
My let it be.
I'll record your name. Don't worry. I'll record your name. I'll protect you because the client should not misunderstand you. I'll record it. I'll do that. Don't worry. Thank you. I'll record your. Don't worry. I'll record that you are.
Okay, Kumar. Okay.
Yes.
All the parties are present. I am filing the lordship the joint affidavit.
Also directed to.
Where are the parties?
Obtain the ones of the year.
Yes. What is the offense? Offense? Huh?
POCSO there.
Case and counter case.
They have not married, my lord. 164 statement they are, my lord.
Your lordship directed last occasion to obtain the 164 statement.
Reading.
My lord. 25/1/2023 ପାଖାପାଖି 8:45 ସେ ମତେ ପିଟିସନ ମାଇଲା 2021 ମୁଁ ରିତେଶ ପାରିକକୁ ଭଲ ପାଉତି ଆସୁଛି 2021 ମସିହାରେ ମୁଁ ତାଙ୍କ ସହ ପାର୍କ ଠାରେ ଦେଖା ହୋଇଥିଲା 25/1/2023 ପାଖାପାଖି 8:45 ସେ ମତେ ଇନଷ୍ଟାଗ୍ରାମ ମେସେଜ କରିଥିଲା ଦେଖା ହେବାକୁ ମୁଁ ଅଳିଆ ପକାଇବା ବାହାନାରେ ଘରୁ ବାହାରିଲି ଏବଂ ଦୌଡ଼ିଲି ତାଙ୍କ ସହ ମଣ୍ଟୁ ବୋଲି ଗୋଟେ ପିଲା ଯେ କି ଭିକୁଗୁଲର ତାଙ୍କ ସହ ବାଇକ୍ ଧରି ଆସିଲେ ତାପରେ ଆମେ 3 ଜଣ ବାଇକରେ ଗଲୁ ଆରଡଙ୍ଗ ଆଳୁ ସେଠାରୁ ଗୋଟେ ସ୍କୁଲରେ ନେଇ ମଣ୍ଟୁ ଆମକୁ ଛାଡ଼ିଦେଲା ତାପରେ ରିତେଶର ବାପା ଆସି ମୋତେ ରିତେଶକୁ ନେଇଗଲେ କେଉଁଝର ତେଲକୋଇର ତାଳପଦାକୁ ଯୋଉଠି ରିତେଶର ଦାଦା ଘର ଆମକୁ ସେଟା ଛାଡ଼ି ପଳାଇଲେ ସେଠି ଗଲା ପରେ ରିତେଶ ମୋତେ ସିନ୍ଦୁର ପିନ୍ଧାଇ ଏବଂ ଆମେ ସ୍ୱାମୀ ସ୍ତ୍ରୀ ଭଳି ରହିଥିଲୁ ରିତେଶ ମୋ ସ୍ୱଇଚ୍ଛାରେ ମୋ ସହିତ ଶାରୀରିକ ସମ୍ପର୍କ ରଖିଥିଲା ବଟ୍ ଦି ଭିକ୍ଟିମ୍ my lord is about 14 years my lord a school administrator registered my lord 13 years some months.
What is the age of this boy?
20 years.
20 years.
20 years. But have you read this affidavit which you have given? What have you written? What have you written in this affidavit? Except the name of the victim and appellant and petitioner and respondent, you have not written anything in this affidavit. This is the joint affidavit. And you want quashing of on the basis of this affidavit. Just read it and if you satisfied, then I'll do it. A 482 petition has been filed, we have settled, quash it. This is what you have written. This is the level of affidavit you file. How do you expect that I will quash it like this? Just read the affidavit. At least file the affidavit properly. What have you written? A 482 petition is filed, being CRLMC so and so, we have decided, quash it. Finish. What is the terms? What is the settlement? Whether you have assured to marry with the girl. After all, this is a small girl, and she is being represented by the father. And why the FIR was registered for misunderstanding? Something you have to write so that I can reproduce those things. File a better. Right now. On joint request, the petition is the matter is adjourned. Yes, next.
86.
Next week. Yes, next. 80?
86.
Please, your lordship.
Yes.
My lords, here I am appearing for the husband. My learned friend Mr. Panda appears for the opposite party number 2, my ex-wife, my lords.
Yes.
A settlement has been reached between us. That is, I have annexed the judgment and decree of divorce at Annexure 3, page 16, my lords. And in view of the divorce, we want the proceedings in which
this is only 498, 323.
Yes, my lords.
Yes.
Both parties are online, my lords. I'll ask them to switch on their.
Yes. Please show them. Show their face. At the instance of opposite party number 2, FIR number so came to be registered against the petition. The
petitioner is online, and opposite party number 2 is also online.
Yes. The parties have during the pendency of this petition. Then it is not possible to quash also. Maybe, but I can't. In absentia, I can't do it. How do you know that it is done by them? Tomorrow somebody will complain that it is not some. No, don't take that risk for yourself also.
Yes, maybe adjourn.
It's better that you make them appear in so that I can record. Both of them can appear through VC. I am not insisting them to come. Let them. That's right. Appearing.
On previous occasion, my lord stated that notice should go to the opposite party, and she should appear through his advocate. Now my lord
Where have I said that she should appear through advocate?
Earlier order, my lord. In petition I have mentioned, and the order also, it is stated by the London Council for the petition that despite filing of the present criminal case pursuant to the order.
Most likely to be settled.
He further contended that the opposite party is in advanced stage of pregnancy. It is also contended that the marriage.
I know it is likely to be settled.
Yes.
I have recorded that she is in advanced stage, but okay, let the petitioner appear first.
Petitioner will appear.
Next week. Yes. Start from
56.
Yes.
My lordship, the incident has taken place after 15 years of marriage, and the IO has already submitted the final charge sheet.
Tell me the custody.
So he is from 8th March.
8th March
2024.
24. Yes.
And
charge sheet filed on
2nd July 2024.
2nd
July
24.
Yes.
Go to trial court. By the order dated, the petitioner is agreed by the order dated 30th April 2024, whereby his bail plea has been rejected. Subsequent thereto, on 2/7/2024, charge sheet has been filed. Since the bail plea of the petitioner was rejected during the period of investigation, the petitioner shall renew his bail plea before the court of first instance. With this liberty, the petition is disposed of. Next. Yes.
57.
Thank you. Yes.
May I please, Your Lordship? Your Lordship, the allegations are under section 420 and 409 of IPC, Your Lordship.
420.
Yes, Your Lordship.
Yes.
The petitioner is in custody since 21/4/2024.
21/4/2024. 20.
Lordship, the allegation is that the petitioner, being an LIC agent, has fraudulently transferred the premium amount of one of the policyholder, Your Lordship.
How much?
24,000 is the allegation as per one complainant, Your Lordship. Thereafter, LIC has made a verification and they have stated that they have found similar 18 more number of transactions, which amounts to around 12 lakhs. However, only one complainant has come forward. The other complainants have not stated that they have not stated, Your Lordship. Your Lordship, my contention is that, Your Lordship, the
8 lakh rupees.
12 lakhs rupees, Your Lordship.
In such view of the matter, the legal counsel for the petitioner is directed to file an affidavit stating the manner in which the petitioner has returned aforesaid 8 lakhs for the.
Your Lordship,
that
we've
is
already
not-
filed the affidavit. Your
Affidavit you have
Lordship.
filed?
Yes, Your Lordship. Your Lordship, may
12 lakhs was the total, this thing,
allegation is 12 lakhs.
misappropriation.
Yes, Your Lordship.
And 8 lakhs you have returned.
Your Lordship, I've already, yes, Your Lordship.
Where is that affidavit?
It was
Flag?
it was filed on 12/8/2024, Your Lordship.
Tell me the flag, madam.
Flag.
Yes.
Your Lordship, if I may kindly submit, Your Lordship, the petitioner is 80% handicapped, Your Lordship. Spinal cord and below his does not work, Your Lordship, and he goes for continuous medications, and ever since he has been.
Where have you said that? What is there?
Your Lordship, it is there in the petition as well as the additional affidavit. In the petition, Your Lordship may see the.
Where is the additional affidavit? Additional affidavit you have said that the petitioner only submits that the petitioner has also
Paragraph.
1 lakh so which is already on record and the petitioner false indicated. Yes, the spot is. Where have you said that?
Regarding the medical, Your Lordship, paragraph 7, I've said.
Hmm?
Paragraph 7
of the petition.
of the affidavit, Your Lordship. And I've annexed all the documents, Your Lordship.
Paragraph 7, which affidavit? Dated?
Dated
24
to-
July.
No, Your Lordship, 12/8/2024.
12/8.
2024.
Twelve 2024.
Yes, Your Lordship.
Which flag? Take it out. Shall I waste time like this? Huh?
D1.
D1.
D1. Intermission. D1. Page 71.
Madam, at least you should assist. Otherwise, how will I? 80%. Yes. Yes.
My lord, to that respect, my lord, I have got the instruction. So for the contestant for IA, it is submitted that while investigation of the case, I did not find any disability of the accused, or neither the disability matter has been disclosed to me, nor it was in a visible condition from appearance. No, any medical disability certificate has been.
Do you have any certificate?
Yes, Your Lordship.
Where is that?
Annex 3, Your Lordship, of the main petition.
Annex 3 to the petition.
Yes, Your Lordship. Page 20, it has been passed by the competent authority, Your Lordship.
And as such, it is not just proper to say that the accused is 80% disability to work himself, help of others. That is the IO, my lord, instruction.
No, this is certificate to it. District medical authorities is given the
Yes, Your
certificate.
Lordship.
They have not.
The IO may say whatever.
And in the affidavit also, there are several medical documents, Your
If
Lordship.
there is if something pass on to the IO, he will write he is 100% disabled. Despite there is a certificate, you say no disability. What is this?
And then I will take instruction with regards to
Why instruction? There is a certificate.
The genuineness of the certificate, that is my lord.
That you can
I will
verify.
give the doctor and
That you can verify, but there is a certificate here.
That much, my lord.
Yes.
Order may pass, my lord.
Next week,
My lord.
Mr. Ragada, Land Counsel for the state, submit that he would verify the disability certificate produced by the petitioner in annexure 3 to the petition. Petition. This is the matter next week.
And Your Lordship, if I may submit only one thing, Your Lordship, no
Wait,
charge sheet has been filed, Your Lordship.
Wait, verify. Then if you are disabled, then I will grant bail. In
Yes,
any
sir.
case, you are in custody for about
Yes, Your
till
Lordship.
4 months. Yes. Next.
Your Lordship, fix a date, Your Lordship.
Next week. Next week. Yes. Give the necessary documents so that you can verify. Yes. 50?
59.
59. Yes.
May I please, Your Lordship?
Withdraw. Yes.
Permitted to withdraw.
Yes.
60.
May I please, madam?
Hmm.
My lord, I am pressing IN number 1075 of 24.
10?
75 of 24.
Yes.
In BLPL number 5979 of 24.
Yes, sir.
My lord, in this case, IN number 1075 of 24, filed by the petitioner for the extension of interim bail passed by this honorable court on order dated 19/6/24 for a period of 2 months. Background of this case is that, my lord, petitioner is along with one director, Aravind Samantray, arrested on 35/23 in connection with.
Show me the interim order.
My lord.
Show me the interim
Yes,
order.
my lord, I am reading it out. Well,
Yes, yes.
in EOWPS case number 14 of 22.
Where are you reading now?
No, my lord, I have, I'm showing it to my lords. Annexure A in IA.
Yes. 12th April 2024.
Yes, yes.
Yes, read it out. Which part?
My lord. Page 13, my lord. On paragraph 9, my lord. Under
9.
such circumstances, detaining the petitioner in custody would inure to benefit of no one. On the contrary, having regard to submissions made by learned senior counsel, it would be in the interest of the informant if the petitioner is allowed some time to pay the amount due. In so far as the petitioners are concerned, charge sheet has already
4 months interim order was
given to me. My lord, difficulty is that, my lord, kindly, in this said EOW case, petitioner along with other director.
Yes, Mr. Ragada. 4 months time is granted. He has to pay the money, asking for extension. Let him pay. If you send him behind jail, what is? How much time?
My lord, in this case, 19,90,000.
I don't want to go into all these things. Don't. I'm just asking how much time you want. 4 months time was granted.
2 months? No, I have already held 2 months time, my lord.
Oh, anyway, for another 2 months I'll give. 4 months.
Yes, please. Your lord, give me another 2 months.
By order dated 12th April 2024, the coordinate bench of this court had granted the petitioner interim bail for 4 months. Then consequently, the petitioner submits that he could avail the benefit of the said order and remain on the interim bail for 2 months only.
Yes, only.
Therefore, he could not arrange the funds to deposit as per the direction of this court, as per the undertaking given by him, Therefore, he seeks extension of time, for a period of 2 months. Regarding head to the reasons stated in the application is allowed. The petitioner, the interim order granted by this court by the order dated so and so is extended till further period of 2 months. 2 months, and the petitioner is directed to surrender before the jail authority on or before. After 2 months, give a date on or before certain time. Release the matter thereafter. Okay.
My lord, a small prayer, my lord. Along with that, IN number 1074 of 24, I have mentioned it before yesterday also. It has not come up. It's arising out of the same affair and another director. He may be granted 2 months time because he has not availed the.
Let it come. I can't pass.
Tomorrow let it come.
No. Let it come. It will come. Let one director come, arrange some money, then another director. Both the director remaining outside is dangerous. Wait. Next.
Actually, order was given to him also.
It's all right. Both of you will come and create some problem. Again, you take money from people. No.
Let it come tomorrow.
No. Wait. Let it come. Whenever it will come, I'll give. Yes. Next. 60? 61. Yes.
Modification in bail order lordship passed by SPGM Jaspur lordship.
Which part of the order you want modification?
He granted bail to the petitioner, furnishing bail bond of rupees 30,000 to solvent surety lordship. Lordship, present petitioner is poor person, his family suffering from difficult problem, lordship. That's also she pray for.
Show me the bail condition. Where is that?
Here one. Yes, lordship.
Where is the bail condition?
Bail is lordship page 18, 8 lordship.
30,000.
An issue one.
Procedural shall really be released on bail, furnishing bail bond of 30,000 rupees to solvent surety of like amount. To the satisfaction that this you want variation. 10,000.
Lordship, pray for release on PR bond, Lordship.
Legal case.
Legal.
Pardon, petitioner is agreed by the condition imposed by the court below while granting enlarging him on bail. Counsel for the petitioner submits that the petitioner could not arrange the bail bond of rupees 30,000 and two solvent surety. Therefore, he could not be released on bail. Owing to the financial ability of the petitioner, she seeks modification of the order, condition of the bail. Accordingly, the order dated 29/3/2024 passed by the trial court is modified to the extent that the condition the petitioner shall furnish PR bond. And you have to have a surety also, otherwise arrange a surety. One surety of at least. Personal bond and one surety of 5,000 rupees.
5,000 legal, that's why.
And one surety of. And one surety. Yeah, okay, allowed. Allowed.
62.
Please, Your Lordship. Lordship, I'm appearing on behalf of Mr. D. Naik. Lordship, this we have had challenged a cognizance order. However, the parties have compromised and a notice had been sent, but nobody had appeared.
Notice sufficient, madam?
Yes, Your Lordship, but nobody had appeared for the same.
Somebody mentioned for adjournment. You have mentioned? Okay. Why are you standing out there? Come. Yes, urgent. Service of notice on opposite party number 2 is complete. So and so appears for opposite party number 2 and seeks an adjournment. And the parties conjointly submit that they have settled the dispute. Release the matter.
Your Lordship, the
you appear for her. Okay. Opposite party number 2. None appears for opposite party number 2 despite service. Despite service, in the interest of justice, release the matter.
Your Lordship, interim order may be
Interim order to
continued.
yes. No, service is complete. Yes, it's sufficient. Yes.
Obliged, Lordship.
Yes.
64.
My lord, 64, my lord, I'm on VC, my lord. I'm appearing for the petitioner.
Yes.
My lord, in this case, my lord, the notice had gone to OP number 2, where the noting says
no such person in the address and return to the sender. No such person in the address and return to the sender.
Address, I think address you have to see.
it's a company, my lord. I'll cross check again. I'll verify and provide.
The notice on opposite party number 2 or 2 and 3 could not be opposite parties, private opposite parties could not be served for want of appropriate address. Mr. Mohana and counsel for the petitioner submits that he would be furnishing fresh address of the opposite parties. Please the matter.
My lord, only opposite part number 2, my lord. Yes.
Opposite party number 2. Yes.
In fact,
May I pray, Lordship? In this case, the notice issued 2 occasions and it unserved. Knowingly, the opposite by 2 is avoid to receive the notice. Lordship, direct to state government take
Cannot be located. What to do?
I have given notice.
What are you asking? Passing of FIR?
FIR. No, proceeding, entire proceeding.
It has mentioned there are 2 addresses.
Yes. In 2 address notices.
No. What are you asking in this petition?
GR proceeding will.
Huh?
Entire proceeding will.
Entire proceeding causing. Efforts have been made to serve opposite party number 2 unsuccessfully. It is reported that the opposite party number 2 is could not be located. let service of
So
the
poli-
notice
police
for
will-
opposite party number 2 be effected through the IO of the case.
Yes.
IO of the case, release the matter on such and such. Yes. Free-
66.
Give a free copy. Huh?
Yes.
60?
Six. Extension of time to surrender matter. So your lordship, in order dated 25/2024, directed while not inclined to interfere into the
2025?
20/5/2024. There your lordship directed to surrender and move for bail by 30th June. They could not surrender. All are ladies without
For the reasons stated in the application, the extension time to surrender or appear before the court below is allowed, and petitioners are granted further opportunity for appearing before surrendering before the court below on or before 15th of September. 15th of September so and so, and avail remedy under law. It is made clear that no further for further extensions shall be granted in the
15th holiday will your lordship may say 18th of September.
18 September. Huh? Okay, allowed. Yes.
69.
Yes. 69. Yes, sir.
My learned friend was to answer regarding that sanction thing.
Yes.
Your lordship may kindly ask to refer to section 19 of the DCR.
Yes, tell me. Don't read notes.
Error includes competency of the authority to grant sanction. It is in the explanation.
Yes.
And it in section 19, subsection 3, A may be reported.
Yes.
No finding, sentence, or order passed by a special judge shall be reversed or altered by a court in appeal, confirmation, or revision on the ground of the absence of or any error, omission, or irregularity in the sanction required under subsection 1, unless in the opinion of that court a failure of justice has in fact been occasioned there.
Yes.
My lord, in this case, your lordship may kindly paper book volume 2 may kindly be referred.
Yes.
Page 247, paragraph 58.
247.
247. Paragraph 58. Your lordship, what?
Para
58.
page
247.
247.
Para
58.
47. Yes.
In this case, I had pre-sanction discussion with the sanctioning authority. Additional Secretary GA Department was held on 16/2/2010. During discussion, all relevant documents were shown to the sanctioning authority with your lordship may kindly have a
Additional secretary.
with additional secretary, sanctioning authority with additional secretary, along with all connected documents, including FIR, case diaries, statement of witnesses, statement of the accused, which were seized and collected by me during investigation.
Right.
Your lordship may kindly have a glance thereafter to PW 50, PW 50.
Page
Page 225. I will permitted to read the evidence adduced.
225.
225.
Yes. Yes.
On 5/4/2011, I was working as officer on special duty in GA department. Prior to this date, the Vigilance sought for sanction of prosecution against Sibo Sankar Mishra, DSP Homeguard Sambalpur, on the allegation of possession of disproportionate assets by him during the check period from 1/1/1995 to 12/1/2006. The proposal was proposed in GA because processed. Your Lordship may kindly have a glance at processed. Processed in GA department. That means which your Lordship was scoring on the last occasion, additional secretary, then this came to him. So processed in GA department, and I held pre-sanction discussion with the IOS, the SK Florida GSP Vigilance.
This
Your Lordship, I am reminding PW 17, which I read in paragraph 58. He said IO, SK Florida, which I read prior to this.
his office.
He is the IO, SK Florida. Your Lordship, may kindly have a glance to his name at page 236. 236.
Then the escape, according to you, the escape Purida has placed all these things before
All these things before
the
them,
department.
he was the IO.
Department, before the department.
Before the department. Thereafter it was processed, and thereafter it was put up before him. Thereafter I am reading, your Lordship, may kindly have a glance.
Then OSD has given the sanction.
No, he was appointed as the OSD, no, by the government. So how it has been processed, I am reading.
Yes.
The proposal was processed, and I was in the escape order DSP Vigilance, who appeared before me along with documents in response to the notice issued against him. On perusal of the relevant documents produced and after discussion with him, I was satisfied that there was a prima facie case against the suspected officer, and after due application of mine, I prepared a detailed note and submitted the file along with relevant materials to the Honorable Chief Minister through the Deputy Secretary and Chief Secretary. The Honorable Chief Minister approved the sanction of the prosecution. Thereafter, I signed the sanction order on behalf of the government. The said sanction order is marked as Exhibit 22, in which 22/1 is my signature. The said sanction order was communicated to the GA Vigilance Department by letter number 7188 dated 6/4/11.
Where is the exhibit?
Exhibit is 22.
22. Exhibit page 22. 22, eh? 22 of who?
22, exhibit 22.
I know, what is which?
That is not in the paperwork. That those have been kept separately. I am not having my copy.
So, exhibit.
My lord had marked it in the last occasion.
Yes.
It was flagged also.
Exhibit.
मत देखेले?
Yes, yes. That's yes. Yes.
And by the order of governor, the sanction order has been given by the state government. So for state government, I may refer to your Lordship. The General Process Act, Section 3.
Written submission.
General Process Act, Section 3.
Written submission. Mr. Das, written submission. You given a written submission, no? You have given a written submission?
No, I could not get the time to go.
Then I
regarding sanction, I
that's right, but I how will I record in the written submission only? I record it so that it will.
Written submission I have prepared part.
But those things you reproduce, okay. General Clauses Act, okay. Yes.
So, General Clauses Act, Section 3, State Government 60, Section 3, subsection 60. State government in the as respects anything done before the commencement of the Constitution shall mean in a part A state, a provincial government of the corresponding province in a part B state, the authority of person authorized at the relevant date to exercise, execute government in respect in the corresponding exceeding state. Your Lordship may kindly have
Yes. Yes.
Section 3, subsection 60. A.
Yes. Yes. As respect anything done before the commencement.
As regards, as respect the authority done after the commencement of the Constitution, before the commencement of the Constitution, Amendment Act shall mean in a part A state, the governor, in a part B state, the Raj Pramukh, and in a part C state, the central government. C, as respects anything done or to be done after the commencement of the Constitution, 7th Amendment Act 1956 shall mean in a state, the governor. On this aspect, for this sanction, I would like to refer to 4 citations for sanction. The Lordship may kindly have a glance to the citations. First of AIR 2010, I will give the copy. I have not.
Without the copy, how can we?
No. I am just referring. I will make a note and I will give the copy to my learned senior with respect. With respect, I am submitting that. I will supply the copy. I am just referring to the Honorable.
Yes.
In
And
this
you
case,
do you have an additional copy? Give an additional copy so that you can.
extra copy I have brought. 2 copies. I am just referring. So the learned respected senior counsel junior may noting AIR 2010 Supreme Court 1451.
Yes.
State of MP versus GR. Sanction for your Lordship may kindly refer to paragraph 7, page 1453.
Yes. Yes.
In the case before us, even if it were to be accepted that there has been an error or omission or irregularity in the passing of the sanction order, the learned single judge of the High Court has not made a finding which shows that a serious failure of justice has been
The
caused.
same thing, 19 you read the 19.3, same thing says.
That has been discussed in this
Yes,
decision. Paragraph 9 may kindly be said of that decision. Not consider the appellant merits to decide whether a failure of justice has been occasioned in the present case, set aside the judgment.
Yes.
Next decision regarding sanction, your Lordship may kindly have a glance to AIR 2016 Supreme Court 1554 Balabhadra Parasar.
Of the same proposition.
Yeah, regarding sanction.
No, proposition is same.
Proposition is same.
If it is not prejudicial and
Yes.
then
Thereafter, the third one is 2023 92 OCR Supreme Court 309
Subegoda.
State of Karnataka Lokayukta Police versus S.
Subegoda.
The next page, your Lordship may kindly have a glance to page 310, the combined reading. Your Lordship got it?
Yes.
Page 310.
Yes.
That thing has been discussed. And the last one is that 1972 Criminal Law Journal 1349.
Yes.
State of Punjab versus Om Prakash Bharwal and another.
Which paragraph?
Your Lordship may kindly have a glance to paragraph 64 and 65 at page last page 1376. I hold therefore that under Article 234, the governor acts only in his capacity as the formal head of the executive of the state. He does not act therein in his individual capacity or individual discretion or individual judgment. Further, that under the said article, the governor merely exercises the executive power of the state vested in him by the constitution.
This is general law.
Yes, 65 paragraph 65 be referred to. So in this case, state government has accorded sanction by the order of governor. My submission is that this question regarding irregularity of sanction, illegality of sanction, nothing has been put to the IO. None of the IOs. 3 IOs have been examined in the trial. So this question has not a single question has been put to any of the IOs in course of cross-examination, except one question to the previous IO, PW16, that to whom you have examined. Your Lordship may kindly have a glance to page 233 of the paper book, volume 2. Only one question. I have not examined any witness in this case except him, Sri Dhobai Charan Saab.
Page, page.
233, cross-examination, para 9, first line. 233,
Yes.
first line, cross-examination.
Yes.
233, page, paragraph 9, first line.
Hmm.
Except that question only, nothing has been put to any of the IOs regarding illegality, irregularity of the sanction accorded by the government to prosecute this appellant under the
Para 9. Para 9.
Para 9, first line.
I have not examined any witness.
Except Dhobai Charan Saab, PW 16, who has signed the sanction order.
Yes.
So PW 16 in his evidence has categorically deposed that I have examined Dhobai Charan Saab.
Yes.
229.
229.
229, paragraph 3. Your Lordship.
Yes.
On 18/4/11, I received the prosecution sanction order from SP Vigilance Sambalpur by forwarding letter number 140 dated 15/4/11 according sanction of prosecution against the accused Sibo Sankar Mishra, OPS, DSP, Hon'Ble, Sambalpur.
Yes.
This said sanction order is already marked due 22. Therefore, I examined.
Yes.
It's in Dhobai.
Anything else?
Dhobai Charan Saab.
No, I understood it. Anything else? You want to?
Yes, regarding that sanction order, I have submitted, as your Lordship wanted to know about irregularity or abstaining. First of all, section 19.
19 covers you.
Covers. So the sanction order has been rightly given by the state government to prosecute this appellant under the provision of law. My submission before Lordship and the 4 decisions I rely on. Also
Supporting 19.
contentions
Right.
regarding sanction
Right.
19. So far the DA case is concerned, Your Senior, with respect, if my Senior argues
Yes.
today,
Yes, yes.
The sanction, I think you may not succeed in sanction point.
Only in sanction, my lord, I'll succeed. Law is no more res integra, my lord. My lord, very interesting point of the sanction. Any administrative order, my lord, has to speak for himself. Here, my lord, they don't even say that the officer in special duty.
I think section 19(3), which he read it out, is only to cover this kind of situation.
No, my lord, it doesn't. My lord, the matter is no more res integra that the authority who gives the sanction has to be the appointing authority. And if in event it is there are 2 aspects, my lord. Prejudice is rightly, prejudice has been caused or not, I have demonstrated earlier, I am demonstrating again, my lord. My lord, what happens? They discuss. The entire case diary is supposed to be before them.
You are questioning the sanction on the ground of prejudice or invalidity?
Invalidity as well as prejudice, my lord. Because they do not make available all the material before the sanction authority. My lord, kindly visualize. I placed before my lord understood my argument to be that I am saying that there was an enormous amount of delay between the search and the first information report. No, my lord, my submission is not that. My submission is this very PW, who is the investigating officer, examined, wrote to the state government and wrote to the IG police, which is part of their record, for which I have asked a specific question to the IO, who says that yes, admittedly on day 1, I said that there is no case. And between the day 1 and the day on which the charge sheet is filed and the sanction is asked for, my lord, there is no material change. He says it is less than 5%, and it will not be subject to judicial scrutiny. It has to go.
Interdepartmental communication.
That has to be, my lord.
If it is not culminated into a final order,
No,
cannot
it
be
is-
relied upon.
No, my lord, I'm not on that. That is one of the material that should have been produced and taken into consideration by the sanctioning authority. That is my prejudice, my lord. I saw the law. The law is very clear. Every material.
But these are, again, the prosecution, the IO has a discretion to rely which document.
No, I know. IO has sent the entire thing. I am only saying that this portion has not been seen. My lord, the law is no more recentigra that in event there is a prejudice caused to me and some material that was available on record has not been provided to the sanctioning authority and the sanctioning authority has not applied its mind to that, that makes the sanction vulnerable to. That is my submission, my lord. This very material, my lord.
No, the other day you have already argued that point.
Yes.
You say that all the materials were not placed. Placed before whom is a
sanctioning authority. Sanctioning authority.
But what he says is he is emphasizing the word processed. The document, all the documents were placed. The other day, what we were wondering, the document were placed before someone. Sanction is given by someone else.
Exactly, my lord. That also.
But he says that it is processed.
No, my lord, it is not. My lord, I will produce, I'll give an affidavit.
And he emphasized in two words.
Yes.
In the evidence. One is, it is processed, so it has gone through many people. Second is, when it was given, he was sitting with the additional secretary.
My lord,
he is emphasizing the word.
I'm asking, is the additional secretary before, is this the sanctioning authority, therefore has to be the additional secretary? Has he signed that document? My lord?
It was given by Chief Minister, he is explaining process.
No, it came through the Chief Minister, not given by the Chief Minister. My lord, they have to produce. The law is that they have to produce the sanction, the entire process before, my lord. The law is that, my lord, they are supposed to be, once a challenge is there to the sanction order, which is cryptic, they have to make available the material before, my lord, to examine that. Because it's a very serious matter, my lord. The concept of sanction itself is a very serious matter.
Do you have any supporting judgment to say that in the appellate stage, I can call for the entire sanction process to examine it?
No, my lord. In event, I can show that the material was not taken into consideration. That itself makes it vulnerable.
That's right. You are right. There I am agreeing with you.
Yes. That, my lord, I'll demonstrate from the order of the deposition of the interesting reading, my lord. The man who says that he was the investigation authority right through. I'll just paste that.
So then I'll list it some other day. Let him give the written submission.
Yes.
Because sanction also, he has clarified some position.
I want to contribute judgments also. I'll give them my learned friend the judgments also. I've given it in last occasion.
So you get ready on merits also. I will have to go get it.
Last week of September.
I'll have to go into the merits also.
No, sanction, my lord. If I do not get over sanction, my lord.
But he has created. I was completely with you when the other day, but now he's created doubt.
The what rated meet?
No, my lord. That is not. My lord, may kindly see the leading judgment in this line. The judgment of Gavai and Justice Narasimha, which says, according as a principle of administrative law, when applied to the issue that we are dealing with, translate into this: responsibility for grant of sanction for prosecution of public servant under 19 is always vested with the appointing authority. So the appointing authority has to apply his mind, my lord. And the appointing authority here is the governor.
Yes.
There is no doubt about that. Identification of the appointing authority is always clear and straightforward. 2018 amendment specifically obligates the appointing authority to convey the decision within 3 months. Now they have become that 3 months thing. And to provide for the reasons to be recorded in writing an extended period of 1 month. 1 month, if it is beyond, it can be extended to 1 month. Again, you have to give reasons. This amendment, in fact, evidences the legislation incorporation of answerability and the second constituent accountability for enforceability, and the parliament has expressly empowered.
Is it your case? It is the only governor. Nobody else could have given it.
And all the material has to be examined by the
Then
government.
how would you deal with the General Clauses Act Section 3?
General Clauses Act, my lord, only says regarding how, that is the rule of business, my lord. The rule of business does not say that by order of the governor is enough, my lord. My lord, I'll show, my lord, the series of judgments that the appointing authority has to apply his mind. And Dhobbe is neither a appointing authority nor is he the additional secretary, my lord.
No,
He is an ex-cadre officer.
Come to the sanction order.
Yes. Yes,
It
madam.
says.
Yes. I'll read from beginning, my lord. Let me read from beginning, madam. I'll read the entire thing, my lord. Let us, I'll take the pain of my lord.
No. If he says third paragraph, whereas the state government of Orissa, after careful examining the facts stated in the SP report of the above noted case,
yes, my lord.
State government of Orissa and governor,
Yes,
there are two distinct.
Yes, my lord. The governor is the appointing authority. The state, the entire, my lord, like the president of India, everything goes on the president as far as the union is concerned. Every case goes in the name of the governor. But sanctioning is a special provision provided for where all the material.
Was it necessary that entire material should have been placed before
Yes.
governor himself?
Yes. Yes.
Not
No.
through the chief minister.
Yes. Even if it is not before the chief, I'll demonstrate to my lord it was not even before the chief minister. So where is the chief minister going to apply his mind when the entire gamut has not been? My lord, Justice Thakur's judgment is very clear that if there is one material that is not produced, which could have turned the scales in my favor. And that is Orissa High Court also, my lord. Series of judgments. So I am saying that had this material come in where they have admitted on cross-examination, and that is part of my lord's record, that was given also to them, they have not applied.
Might have been a situation where sanction would not have been given out.
Yes, that is all.
So therefore it is prejudiced.
Yes, my lord. My lord, the law is that every material, and especially the material that which can tilt the scale, has to be made.
It needs
Yes,
deliberation.
Yes. And my lord, my colleague say I'll give the judgment of this honorable court in series of matters, not one.
Then I'll fix it 3 o'clock sometime. You tell me.
Yes.
You get the written submission. Now you got this.
The last decision will clarify the query.
My lord, I will. My lord, I
This 1972 criminal
No,
law.
I read that. I don't.
Yes, that will clarify the entire things. Your lordship,
There's series of judgment
which
thereafter.
Which state government regarding reading to.
No. He said, governor said this is one issue. Second issue, the relevant material. According to him, whereby the opinion was given that no, it is the case is not required to be proceeded further. That material is withheld from the sanctioning authority. That is the prejudice. Is covered under 19.
Question has been put to the IO, whether he has produced.
That is another facet of it.
It has to. My lord, it has to be face of it. The law.
It will be taken in appellate state, where section 19 subsection 3 says so. No finding or altered in the.
My lord, I will show Supreme Court directly taken into consideration.
Then keep it at 3 o'clock.
State.
When, sir?
Whichever, my lord, whichever.
When are you available?
Well, I'll make myself available. Any Wednesday, Friday, Wednesday, Tuesday, Wednesday, Thursday.
Last week of September or first week of October. I will make a back the.
Last week of
October.
25th.
Yes, my lord.
25th. Part head and least the matter.
3 o'clock?
Partly at 3 o'clock. Yes.
I will be listed in the hearing as a hearing.
Hearing.
It is coming on the order on the hearing.
No, let it be order because I have partly heard it. Unnecessary. This time will be wasted unnecessary. I understood it now.
I will give all the judgments before that.
Right. So that
I have given, in fact, my entire written note that I have given to him contains everything. Each one of the judgments. Well, I'll just read one paragraph, my lord, for the purpose that judgment of just give me the judgment of Justice even Odisha High Court. That Yanko.
In any case, 25th to 25th.
No, well, I just want to put one line, my lord. The confusion that has been created, that is not there at all, my lord. It can be raised anytime. And if this material that could have tilted in my scale, that is Odisha High Court also. Justice Patel also says that. The sanctioning authority admitted that he was not examined the documents. Once he does not, every document has to be seen. And especially a document with tilts. But that judgment, don't just give me the Supreme Court, my lord, directly says. Justice Thakur says that
That is there. That is, I am not doubting that proposition.
And my lord, Orissa High Court itself.
Every document, a small one
Yes.
sheet of paper also can turn the entire case.
Exactly. That is the point.
Everything has to be there.
Yes.
But whether these documents were placed before the sanctioning authority or not,
That is the point.
that has to be put to the IO.
No, it doesn't have to be. They say that their own cases in the demonstrated in the exhibit 22 clearly says we had given the case diary entirely. And the case diary itself contains that no case is made out.
Then your argument goes contrary to your stand. If everything was placed, the case diary, then that was placed before.
No, it has not been placed probably. Otherwise, if they have not looked at it, that also makes it vulnerable.
Then what you say, then what is your stand? It was placed or it was not placed?
My lord, I
And
don't
it was
know.
placed but not considered, or it was placed?
No,
You have been arguing it was not placed.
This was, yes, because the sanction order doesn't say that it was placed.
Then your case is the sanctioning authority has ignored that material.
Yes.
Which was then you may be correct. That perhaps the reason you might not have asked to the IO.
Exactly.
It was placed, the sanctioning authority missed it.
Yes.
That is a different argument.
Yes, that's my argument.
So if that is your stand,
yes,
then the earlier stand which you have taken is directly different stand. Then in that context, you might not have put that question to the IO.
Yes.
Because IO has placed everything.
Exactly. IO says
including the document by which he has said that no case is made out, don't proceed and all.
No, and he also admits it in the cross-examination, my lord. He himself admits that I had my first.
Then there is a non-application of mind on the part of the sanctioning authority.
Yes.
Despite the fact that everything was placed before him.
Exactly. And
that's a different story altogether.
Yes. And number two, my lord, the IO himself admits that there was no change of circumstances between the time I had that very material is clear, my lord.
That's that. Okay. 25th. Yes. Next.
70.
I think 70, my lords, I'm appearing virtually, my lords.
Yes.
My lords, I pray for short adjournment.
25th,
You take the pen drive and give a
yes,
copy.
my lords. And in due course of the day, I'll make the I'll provide the copy.
Next.
Obliged.
Ever so grateful, my lord. And
yes,
I'll say we have filed the detailed written note.
Yes.
Including sanction and everything else.
And
my learned friend also should
prepare a note, Mr. Das.
71, my friend was opposing that stay. So therefore, this, I have to take instruction. Stay of consent. Therefore, I have to take instruction because your lordship was also pleased to observe whether I can submit on the main case itself.
You have filed the appeal means you have to submit.
Your lordship wants.
And then you file the appeal, then you seek instruction whether I argue or not.
No, may I just clarify one thing? But if it comes in due course, it goes miles. Your lordship knows. So your lordship.
You want that this appeal should die naturally.
No, I don't want that. So I was only praying if your lordship defers it for 2 weeks, I'll just take instruction with regard to placing the matter on
let it be in the board. Meanwhile, whenever it reaches, you send your junior if it reaches. Otherwise, you can seek it.
It has to.
It's all right. I'm accommodating.
No, I was praying for 2 weeks time.
Because
I have to call that party.
Place it after 2 weeks. After 2 weeks, thereafter, whenever the weekly is there, increase. After 2 weeks.
Okay. So that I can get ready.
This affidavit which has been filed by my lord.
Wait, he's seeking instruction. You want to say?
On the previous occasion, served a copy. That the petitioner has the.
Ignore everything. He will seek instruction. He will argue and finish it up.
He has been dismissed from service. So the petition which my lord friend is pressing before your lord.
Did I press it now?
No.
He has not heard me possibly.
Why unnecessary getting into? He is asking for it.
The application will come.
Everything will come. Everything will come. I'll decide appeal. I'm interested to decide appeal. I'm not interested in application at all.
The LCR is not there.
LCR pen drive is there.
No.
Take your pen drive and get ready.
It is not mention in the cause list whether the LCR has been received.
So
Is
once
there,
an
is
appeal
there?
is
LCR
admitted,
is there?
may
Call
may
for
I
the
just
LCR.
clarify one thing?
I'm calling for the
हाँ,
LCR.
normally
Calling for
office call for करथिबा कथा. Once the appeal is
In
admitted, the
fact,
registry does it.
ଆସିଥିବ କିନ୍ତୁ
And your lordship may direct
call for
tagging
LCR.
in the meanwhile.
List it for disposal after 2 weeks. Okay.
72 and my name doesn't find place in the cause list.
Yes.
He is omnipresent. I think name is not
No,
required.
unless my name finds place, I can.
Right,
find in the list.
his name should be
And
written.
date of Orissa within bracket vigilance may be
Vigilance.
reflected. Otherwise, I will leave that. Unless vigilance is written.
And you know, this court only hears the.
No.
vigilance appeal.
Honorable bench in court number 2 also directed the registry to reflect vigilance in the bracket.
Right on vigilance.
And his name also because he
I mean, name is very
Ah,
important.
yes, yes. Free copy also. Your Lordship, the item 72, my lords, on behalf of my colleague, Mr. Maranam, Lord, let it come day after tomorrow. I have stopped it.
My lord, what I beg to submit, in these case, 3 disposed of records have been tagged, and wrongly one record CRLMC 273 of 19 is to be tagged, and instead of that 373 has been tagged.
Disposed of case.
Disposed of cases.
Up to
My lord,
19.
Proper record is CRLMC 273 of 19, but wrongly there is an order earlier for which CRLMC
No, in the call list, just in the call list, just see.
373 of 19 has been tagged.
Correct.
Correct kodakon.
Correct is 273.
273
of 19.
273 of 19.
This record is to be returned.
For the correction. Yes.
73.
My lords, on behalf of Mr. Sahu, may I please? But here, in this present petition, the institution of a second FIR against me has been challenged, my lords. My lords, may kindly see Annexure 1 at page 17. Here the complainant, the second FIR has been instituted on the basis of direction under 156(3). Here the complainant is, my lords, Basant Kumar Behera.
Basant Kumar
Behera.
Yes.
Second.
You are Subhagya Kumar Mudli. Basant Kumar Behra is the complainant.
Yes, sir. Order dated 18/4/22, the lordships are directed.
18/4/22.
Order number 2.
Order number 2.
Okay.
List this matter on 11th July 22 along with CRLMC number 501 of 22 as prayed for by learned ASC to take instruction and to file a reply as to whether the present complainant was also one of the complainants in the earlier case.
Madam, what happened in this case, my lord? Initially, one case was registered, my lord. One case filed, my lord. Then that sent under section 156 of Circular 3 to the police station, my lord. During course investigation, my lord, one of the co-accused, my lord, he has been arrested, and preliminary charge sheet submitted against him, my lord. And the investigation kept open. In the meanwhile, another, my lord, the subsequent case, my lord, that is in the year 2016, my lord. And 2017, another complainant came forward, filed another, my lord, 1/6 case, stating there and that, mentioning the matter. There is a column, my lord, in the complaint case, whether any case earlier instituted or not, my lord. He stated, yes, instituted, and the charge sheet submitted against only one person, keeping the investigation open. Then only, my lord, the court, my lord, the court below, my lord, sent this second, my lord, complaint case, filed by another, my lord, another, my lord, person, my lord.
Who was the first complaint? The Basant Kumar Behra.
My lord.
In the first case.
My lord.
First
Yes,
case, a group of people.
Basant Kumar Behra.
Group of people, your lordship may kindly see page.
And in that case,
64.
subsequent case, my lord, charge sheet submitted against, my lord, against 10 persons, including the earlier whose against my lord charge sheet submitted, my lord. Thereafter cognizance taken, my lord. So when there is prima facie case made out, 1 crore something, my lord, misappropriated, my lord. They have taken money 1 crore, my lord. Right element charge sheet submitted, my lord.
May I explain, my lord?
Yes.
If your lordship kindly sees page 64.
64.
64 is the FIR. This is the translated copy. My lords, the wording is Ame Nimna Swaksharakari Gana FIR Dal.
We the undersigned. And we all the undersigned have given the
Putting agreements and writing that some days residents of Shri Sarita Kumar Muduli, Tukuna Muduli, Sham Sundar Muduli, Tapu, sons of Master Capital Services have taken millions of rupees with an assurance of returning 2 to 3%, but neither they return the money today and tomorrow. They have been saying when we ask for money, this is the FIR. Now, my lords, this is signed. We the undersigned, your lordships may kindly turn to page 66. 66. Fourth name from the top is Basanta Kumar Behra.
Basanta Kumar Behra, Rabina.
Basant Kumar
Mahanti.
66, page 66.
66.
Again.
But very lot of people have signed.
A lot of people have signed, amongst whom
30 people.
They have money taken by lord by the person,
Let me
company.
complete. What is my case? Basant Kumar Behra, you have filed an FIR against him,
Earlier.
along with 29 others. I think 29.
Yes, 29
41
Along with 41. You have filed an FIR against me for the self-same crime. Now, the police investigates, exonerates me.
Not exonerate.
Yes.
No. Police
Keeping investigation open.
investigate it, file the charge sheet against one of your accused.
I'm not a charge sheet accused.
You are not charge sheeted.
No, I was
173 8 was kept open, and thereafter a fresh FIR was filed by someone else who is not a party to this signatory.
No, my lord.
Subsequent matter, once is case
Just
filed.
let me first explain my facts, then you go. Then this self-same Basant Kumar Behra, if someone else has filed, I have no grounds against that. Self-same Basant Kumar Behra, I was not charge sheeted in that case. So that means the police thought that there is no prima facie case against me. That self-same Basant Kumar Behra
File 156.3 once again.
Again, he lodges he files a complaint case that is at running page 17.
17, 170.
Well, if he was dissatisfied with my
then protest petition.
Protest petition again moved another 482 before your lordships. The various avenues open to him. Now, my lords, can he go and file a complaint case against me?
Show me the complaint case.
My lord?
Show me the complaint case which he has filed. Yes. This is 17, page 17.
Page 17.
Complaint cases.
And your lordships may see.
What is your name?
4, 5
and 6. Pankaj Muduli, Sobhagya Muduli.
But he has made accused so many other people.
So maybe, my lords. Against them, he can proceed. But against me.
What is happening to that further investigation?
That case may not be one person arrested and charge submitted against him, and keeping the investigation open, my lord.
Open means not open for perpetuality.
But thereafter, the present case was filed, my lord. The 1/6 case filed by the Anandara, my lord, the Basant Kumar Behra. First FIR lodged by some of the persons.
Who first FIR? That's what I'm asking.
Between Kumar Jena, my lord. And others, my lord. Between Kumar Jena filed the first FIR, my lord. That is year 16, my lord.
No. Then you are confused, sir.
There are 2 cases, my lord.
30 people have filed a first case.
First case, my lord.
Including Basanto. Basanto and 29.
My lord.
And investigation was done.
My lord.
Charge sheet was filed against one of the accused.
My lord.
Exonerating him.
Not exonerating, my lord. Keeping the investigation
Keeping
open.
173 open. Open. Okay. Thereafter, what had happened is that investigation must be going on now.
that is but there.
173.8 is there, you can do it, whatever you want to do. What he did is, once that is going on, another complaint he files at page 17.
By the person.
And making the same guy, this Saubhagya,
And-
is one of the accused.
One of the accused, my lord. In this case, present case, my lord, charge sheet is submitted against this person, showing some of the person are absconded and some of the person are arrested. my
Both the cases should run together.
lord. Exactly, my lord. That is. And he has any grievance, my lord, raise at this point in time.
My submission before your lordship is, my lords, is the second complaint available to be filed? Once, whatever happens there, my lords, if under investigation he is.
You tell me 173.8 what is happening. If you are making him accused in that case,
Since
then
my
this has to go.
And same that the allegation is equal, my lord. But some more accused person added in the second subsequent case, my lord. And 10 against charge sheet submitted in 10 persons, including this petition and both the cases, my lord. And what happened in this case, my lord? That case, my lord, they have mentioned in the charge sheet that the earlier case is there. Subsequently, this case charge sheet submitted.
Are you suggesting that these
Both
charge sheet?
together, my lord.
No, this charge sheet is the outcome of the further investigation.
No, my lord.
And then-
This is separate, my lord. This
Then
my lord.
you have to carry on that.
My lord, take instruction with that.
You carry on that.
Further that-
The counsel for the petition state, Mr. Raghuda, seeks adjournment to get instruction regarding the fate of the further investigation
In
kept
Kalinganagar PS
open in the original FIR number.
PS case number 79 of 2016.
And please the matter entry.
Kalinganagar PS case.
Entry.
Here he also says that I had lodged we had lodged an FIR because these people were not added as a charge.
I understand it. Technically, this complaint is not maintainable.
That is what I-
What see, they should have, if your name would not have been there in the accused list, perhaps it would have been.
Mal.
But since you are there, earlier your name was also there. So ideally, 173.8 they should continue. And if they want you to be accused, let them do it.
Master, actually, what happened? The master has to call for import under 210 CRPC from the I.
उसने उठा के वो आया है तो फिर cognizance छोड़ दो.
Well, send the subsequent.
But technically you are stuck now.
I'll take it.
Better you complete investigation and I'll pass it. And if you want to make them accused, make them accused in that case. How does it make difference?
In this case, my lord, what my friend is saying, final form has also been submitted. The first case. I'll give it. Annexure is there. Anyway, next let it come up, I'll show you.
Then I have to give the liberty to file protest petition to this opposite party. You file form. He has a right to file protest petition. This has to go, but he can file a protest petition if the final report has been filed. He can file. That liberty will be given. That will be repetition of the same complaint.
My lord, that can be given in the same.
That will be definitely a repetition of the same complaint. Yes. Next.
74.
Entry mode. 74.
74, my lords, my lord was to take up the matter on last occasion. Last date, in fact, I could not make it myself earlier. I'm sorry for that.
Yes, all right.
In fact, my colleagues missed the list. But it's a matter, my lord, where two brothers were litigating in civil and criminal side for the property. And they entered into a compromise. It was agreed. On the basis of compromise, civil suit got decreed on compromise. As far as the criminal case, they also agreed in this same very document, which they utilized in the civil suit. That criminal case also is compromised. So on that basis, I'm requesting my lords to.
But now he is opposing.
Now, they are not in fact now opposing.
My lord, I had prayed to obtain instruction from my client as to whether he has put his signature or not. Still, he is saying that the signature reflecting on the petition is not his, my lord.
Has he taken steps to recall the decree?
My lord.
You are enjoying the fruits of decree, and now you this is.
My lord, I am submitting.
So why?
I have not completed.
Yes, yes.
My lord, your worship kindly question.
That's the best thing. That's the best thing. Because these people, they are brothers. Settlement took place. Thereafter, a decree was passed. In that settlement, you have seen that I
But I have already gone through compromise petition.
I know, being a lawyer, you have, you are holding a brief what to do. Reserve, huh? Reserve. I'll pass it. Yes.
75.
Mother of the complainant. The cognizance has been taken against the 84-year-old man. The guy said, one plot was allotted, one land house was allotted to the husband of the petitioner. Way back in 86.
He is now 84. Interim order is there. Adjourned. Let the interim order continue. If the other people want to fight it out, let them fight it.
Purely based on civil.
Whatever, now I have protected you, interim order is there, you. Yes.
70. Hello, interim order shall continue.
I am opposing for that. Interim order should not be extended. On one hand, he is enjoined the interim order. On the
No, like Kalias, again, he is opposing my lord. Tomorrow he will be taken up, my lord.
Midnight you come, I will be there. Yeah, you can't have your own convenience. Tomorrow,
No, my lord.
means tomorrow other people. What about the other people, those who are waiting?
My senior age, my lord,
Whatever.
objecting.
Don't make unreasonable request. Yes, next.
And he should not be, my lord, protect objection this like this.
Okay, urgent. Ask for urgent.
78.
Yes, yes. Yes.
78.
Yes, yes, madam. Which one? No problem. Yes.
Order 5/2/2022.
5/2?
5/2/2020.
Yes.
The board is you run to act that whether prior sanction as required under the Unlawful Activities Act was taken up. And section 124 of the ICC that has been taken by the Honorable Supreme Court. Now the new code, it has been deleted. That was taken, no proceeding can run. B.S. Ambedkar versus State of Maharashtra. So Lordship had elaborately
Yes.
the order supplied to and presently to take further proceedings. This is the state. Now the state government has to receive instruction whether a sanction needs, that's a valid sanction as required under section 45(2) of the Unlawful Activity Act has been obtained in this case, or the whole proceeding is rejected.
Yes. Have you seen my order there dated
Actually, my lord,
5/2/24?
Actually, my lord, what happened yesterday, I have received a wrong file. Today, I have got just this file in the lost time.
Okay.
So I have not
It's
gone through the.
all right. Interim order to continue. Leave the matter after 1 minute.
79.
May be the lords. But in the meantime, the
Only limited
The prior
instructions.
sanction was, valid sanction is there.
I read that order. I have written everything. Yes. Very simple. Yes.
in the meantime, the notice has been served and the advocate on behalf of the informant has been appeared and the petition seeking for quash the cognizance order dated 1/9/2022, my lord. And that because the matter has been amicable settled and there is a Vaishnava has been annexed here with as annexure to my lord.
Where are they? Where are they?
My lord, in the page no 28.
No, the parties are there.
Yes, my lord, the informant.
Parties I am asking. He is not.
My lord, the parties are not
Bring
present.
them. Urgent for a week. Bring them. I'll pass.
Yes, my lord.
Yes.
81.
First Lord Sundaraj.
He was having reservation. But he has some difficulty, personal difficulty.
raised to the High Court and both the officials, the High Court quashed the order. And again, the second quashing of the order, and when the department went to state, went to Supreme Court also did not entertain the SLP. And state gave an undertaking matter before the Honorable Supreme Court, that we will take fresh steps in the High Court. That is the undertaking. I just take your lordship to page 162.
162.
160. This is the SLP order.
Annexion?
Annexure 60. On the feet of all these orders, another proceedings. 100 from the perusal of the input order is transcribed that the High Court order is based on statement made by the advocate general that director cannot direct the deputy director to suspend the license in case of suspension of license. In fact, the first suspension we paid 25,000 and it was compounded, dropped. So sitting was dropped. On the same, very same, again, they suspended. Second time. So the High Court said that part of the order, let us read two lines, 158. It appears that 1 second the Deputy Director Mines Joda directed for suspension of the petition company's license until further order. This is the observation of the High Court. And after giving this, it was it. So you can't direct the Deputy Director to act in a particular manner. So you are the appellate authority. You can't direct to seek on.
Correct.
The scissor to scissor like that. Then number 162. Confronted with this, the Advocate General himself considered that no, the director did not have any power to direct. Confronted with this, the learned counsel for the petitioners in the state, in the Supreme Court, seeks withdrawal of the SLP to enable the petitioners to make an appropriate application before the High Court. So this was the entire ambit of the order. Exactly 13 days after, Vigilance, the director manipulates the Vigilance to launch proceedings. Exactly after 13 days, proceedings were launched by the Vigilance. So my submission is that this is on the teeth of all that. So that's why I would say that the lordship can stay further proceedings. There are, I know the lordship limitations when we are being a stay of trial and all that. There are cases and cases, and this is the case where the teeth of two High Court orders and the Supreme Court order.
As far as High Court, I have within this time I have gone through what I have gone through, subject to correction. Thing is that the case my Lord Senior is pressing, that is in respect of cancellation of a license, and our case is not in cancellation of a license. Our case is license was granted in favor of for a particular purpose for utilization of the material for that particular industry unit, and taking that advantages of that license, he has made export to his sister concern, thereby causes pecuniary advantages to that concern and obtain pecuniary loss.
He says that it is a malified action because of these all this.
No, that is not malified. So, and the case is CS is filed in 2018, cognizance in 2019. It is challenged in 2023.
No, after this 13 days after this Supreme Court judgment.
No.
3 to 2020, the order was passed.
My lord.
When you lost the FIR?
The FIR that is in 2014.
Tell me the dates.
That is 19 to 2014.
Read the FIR when the real cause of action had taken place.
Our case is something different.
I know when you got to know about these offense.
There must be some inquiry prior to that.
Show me something.
I'll show. Thing is
show
that now
otherwise
no.
You are so wiser now to
no. A case like any other case, your lordship kindly see.
It looks like an ego issue of the director.
No, it is director. Amara it is director or किसी नहीं.
He manipulated.
And so far as that case is concerned, there your lordship kindly visualize what has happened in this case. What I have gone through. Their permit license was cancelled by the deputy director, and that was cancelled. That was cancelled by the Hon'Ble High Court, suspended. That was suspended by the deputy director. That suspension order, deputy director, this Hon'Ble Court held that no, that the deputy director has not to do it. Our case is something different. He obtained license for utilization of a material.
Something else.
Your lordship is saying that after this.
Why have you waited till the Supreme Court passes this order and thereafter 13 days?
No, it is not within our knowledge whether Supreme Court has passed knowledge. Whenever knowledge, it will come to the knowledge. When a crime will come to the knowledge.
You are the state, you have all the knowledge.
State.
I would, since you have personal difficulty, I am putting it next week. If you don't satisfy, I'll stay.
No, they are enjoying the interim protection. They will file interim application. No, stay so far as the PC Act of bar is there.
That is why I said.
Your lordship I have called the IO. The lordship kind of
volunteer. Tell me.
The lordship 9 through 18 more 18 month more.
Tell me
23rd.
23rd. And the request of the joint request to release the matter on 23rd for final disposal. The interim arrangement made by the order dated
24/7.
Here, order dated 17, na?
24/7. 24/7. 24/7.
24/7. Shall continue till next Saturday.
Wait, I didn't copy.
Yes.
81.
I'm challenging the cognizance, my lord, cognizance order. That is 7/12/25, 15, my lord. Here, my lord, the company is not made in party. So it is applicable only the Hara case, my lord. The lordship kindly glance to page 11.3. The check issued by Joy Santosh.
Service is complete.
My lord.
Who is appearing? Service complete. Receive.
Notice.
Sufficient. Wait. Despite sufficient service, opposite party number 2 has not entered appearance. Yes. What do you say? So and so appears for opposite party number 2, 6 1 week adjournment. Please the matter so and so entry mode to continue. Yes, next.
82.
Yes. Mediation report is there. Offense? Taxi. The who I have sent you to for mediation.
Yes,
right. Which order? Yes. Why the order dated 7/9, na? No, 7. No. 7/5.
7/5. Yes, Lord.
7/5. Why are you giving wrong date? By the order dated 7/5/2024, the matter was referred to the High Court Mediation Center. The Mediation Center flag. The parties have submitted to mediation, and mediation came out to be successful. The mediation, Orissa High Court Mediation Center, by letter dated 9/7/2024, has placed on record the mediation report dated 9/7/2024, inter alia stating as under pursuant to the successful mediation. These have now parties are praying that the criminal prosecution. Criminal prosecution initiated by the opposite party number 2 against the petitioners shall be passed, taking regarding head to the fact that the parties have settled their dispute through mediation, referred to by mediation by the High Court of Orissa. The so and so is passed. ठीक है,
In first case, I am for the petitioner. Second case,
अलग ठीक है. Same common mediation, ना? Pass. Both the cases disposed.
83.
May I please? Yeah, Madam, I have challenged the order of the London Trial Court, which rejected my application of section 311 CRPC to recall Petition 1, 2, and 3. And because of the fact that some development has been there and the party has settled, my lord is kind enough to issue note to the opposite party, the informant, my lord.
Service.
And my friend is also appearing.
Yes, what do you say? Huh? Sorry?
Subside is
Next. 84.
83 interim order is there, ma'am.
Interim order. Yes. Interim order. OP number 2 projects. Yes.
85.
Consider back. I prefer a short adjournment.
87.
87. Non-APS in interest of the yes.
88.
Yes, sir.
Can do one first. One first.
Yes, next.
90.
Yes, 90.
My lords, here the referred the order rejecting my application for signature. The
But charge has been framed, Ross.
Charge is
No.
No, the status report has come.
No. My instruction is that charge is not.
No, in fact, the at flag A, my lord, the status report is there.
No, in that case, I will get the certified copy. It was not paid.
No, it was fixed for 10th April 2023 for framing of charges.
My lords, it has not paid.
You just seek instruction, no?
Well.
The counsel for the prisoner seek an adjournment to get instruction regarding the status of the case before the trial court. Please see matter. Yes, next.
92.
92.
The vigilance of the senior, don't think is having the.
He is saying that he will take the entire LCR through pen drive and will supply the copy to me. Will supply the copy.
Mr. Pradhan, legal counsel for the appellant, revision appellant, states that he would prepare a paper book by obtaining soft copy from in the pen drive and supply a copy of the same to
entire document.
And thereafter the matter could be heard. He may do so within a week. Please the matter immediately after week. 2 weeks.
Mr. Pradhan is appearing in the first matter, my lord. Other two connected matters are there.
Same.
Same.
One paper book.
So one paper book will be prepared.
You get ready 1 week. After 1 week, I'm ready. Date will be fixed. You will give it. Yes.
1 week, 6th of May, 6th of September, your lordship has already fixed one matter for hearing.
Not 6th. 11. Get it ready. Your juniors will get it ready. It will take it time. And get a copy and give it to him also. So that paper book business is taken care of.
Reject.
Once weekly list, item 29. I have received the instruction today. The appellant is no more. So that
29. No more from?
From Cuttack SP.
Cuttack SP. No
Date
more.
of
Abated.
death is 25/3/16.
25/3/16.
Yes. Item 29, CRLA 68 of 2009.
Yes.
But item 88 entry mode expire kari jaise.
What can I do?
Tomorrow
Tomorrow not possible, sir. Just keep the people.
entry mode continue next week. My lord, compromise better. Item 80.
Yes. And any matter? Any regular matter? Yes.
List 137 lords, they were mentioned in the morning. When we accommodated Monday to.
Why can't it be, see, the regular matter, if you want to argue, it will happen at this time only, or 10-15 minutes before. You get ready, argue now. Tell me the facts at least. Every time you, I have seen you, you have been mentioning every Monday.
But you have a long list, lordship, that's why.
That's right, every day this will be like. If you want to argue, argue.
Please, my lords. My lords, in 1999.
Oh, so give me the paperwork.
Criminal appeal 308.
What is your case?
My lords.
Otherwise, don't mention it.
No, my lords, I will take it. My lords, narrate the facts of the case, lords.
Give me the facts at least. What is this?
Criminal appeal 308 of 2011.
Which is this matter?
308 of 2011 lordship. So I weekly 137.
137. 137.
Yes.
And throughout your life, it will not reach. The manner in which we are proceeding right now.
Let me give the background of the case, lordship.
Yes. Yes. Tell me.
Pursuant to a complaint that there has been a construction of a bridge without tender, a vigilance inquiry was initiated and a search was conducted in the year 1999. 99. Against 3 persons, including the appellant.
What is your age by now?
85 lordships. And one of the appellant is in between passed away lordships. The appellant in the first.
He is passed away.
He is passed away.
That is abated.
I can't say on that thing, but some of the council is engaged in that matter.
Okay.
But the thing is that, in that particular bridge construction, the allegation is that the bridge was constructed without following Appendix 9 of the OPWD code. That is a violation. So
who are you?
Well, I was the senior project manager, having a competence of 50,000 rupees for tendering. Beyond 2 lakhs, it is the MD and the ED.
Okay.
Neither I am the MD, nor I am the ED, nor I am the.
What was the project cost?
Was 1.64 crores.
Then it is beyond your
beyond my financial competence, madam. And there is a tendering committee which is Appendix 9, that is the regular course of tender. And in that, the procedure is followed with Appendix 7, which expressly states that you can proceed with the work in case of flood and other emergent situations. It is recorded in the tendering committee minutes, approved by the MD, the chief engineer, and the government.
Yes. In
this, there is not a rupee that is said to have been lost by the corporation and the accused person. This is the brief background of the case, my lords. And our defense was that this particular appellant, he didn't have the financial jurisdiction to conduct any matter beyond 50,000 rupees as per the code. And this is 1.64 crores. There's a profit of 1.16 lakhs in the transaction. And apart from the corporation charges, my lords.
Yes.
Long and short is that he is not at all involved in the case. And they have prosecuted him under this for 13(1)(d) for misconduct, my lords.
13(1)(d).
1D.
And
rest of the things.
Got the paper. You are Praful Chandra Das.
No, my lords. I am Arun Charan Parida. And one more thing, my lords.
You are?
Arun Charan Parida, my lords. 308 appeal number.
Okay. There are 3 appeals.
3 appeals, my lords.
What happens to the Praful Chandra Das?
He is the contractor. I am not representing him, my lords.
Yes.
And interestingly, my lords.
Who is that then?
MD.
Kumar.
My lords, the MD who has passed, he and this project manager, in their whole service career, they have never worked together. But they are booked under 120B for meeting of minds in the matter.
Are you sure that this accused has died?
But this was what I was informed, my lords. They have abatement application, if I am not wrong.
No, there is no abatement.
Their counsel may be able to assist my lords on this.
Yes, who is appearing for vigilance here? See this. See, this matter, there are three matters. One of for the appellant in the second matter, that is a criminal appeal number 280 of 2011. APFs have passed away. That's what he says. And he is in third matter, it seems.
Yes, my
We are
lord.
in third matter.
308.
The first matter is
Is it connected to each other? So
yes.
all the matters will be hard together.
Abate, you have to get instruction abated or not.
I will instruct Mr. Rizvi to take the instruction in last one.
First one, second one.
Well, the first one, I guess. Praful Das is the contractor.
He is surviving.
I don't know about him, but what I had heard is that the other person, the MD, he has passed away.
So what we will do is we will put it in the instead of we put in the supplementary list.
That will be
Supplementary list. Give it Monday, Tuesday. In meantime, you get verified whether this appellant has died.
Lordship.
Which area? This is vigilance case. Which area?
Bhubaneswar, Lordships.
Bhubaneswar. SP Bhubaneswar Vigilance to submit a report in 280, 280 of 2011 criminal appeal report regarding the well-being and the status of the petitioner, appellant. Equally, in the first matter also, 286 of 11, also same order. But in third matter, you are appearing. Least it
Monday, Lords.
Monday, Tuesday, let it be Tuesday so that you'll get instruction.
Please, ma'am.
2 weeks after.
No, my lords,
Not 2 weeks. Tuesday you put it, get the report first.
We'll submit that day, Lord.
Yes.
Grateful, Lordships.
Thank you.
ପଳେଇଲେଣି